My lordship,
Appear. File submission is on.
yes,
Appear for petition is on.
yes.
The, challenge the order on IA passed by the Family Court Bangalore, my lord. For matter is posted for a cross examination petition, my lord. So IA was moved for insertion amendment application, Your Honor. So without hearing, without giving opportunity to this petitioner, the matter was allowed. Matter is
The fresh matter,
well, 2023, my lord. After service, move ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ. Service ಆಗಿತ್ತು.
Monday,
ನಾಳೆ.
Lordship 2018 LAC matter.
ಆ ಕಡೆಯಿಂದ
2000?
18
give it, we'll see next week, after 15th, yes.
2024 fresh matter, madam. Trial court ಅಲ್ಲಿ FTP proceeding ಬರ್ತಿದೆ ಮೇಡಮ್.
Office objections are complied with.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೀವಿ ಇವತ್ತೇ ಮಾಡ್ತೀವಿ.
If it is complete, it will come tomorrow. Yes.
ಇದು ಮಂಗಳವಾರಕ್ಕೆ ಕೇಳ್ತಾ ಇದೀನಿ. ಮಂಗಳವಾರಕ್ಕೆ.
I don't want it tomorrow.
Tuesday.
Tuesday, yes.
It is 24 matter, madam, 2024. It is in admission, so office objection are all compliant. So,
Yes.
My lord said this matter is, an order is passed by the court, under section 23 of DV Act, my lords. And interim maintenance is given. The petitioner is aggrieved by the, finding given by the court below, that where they say that
No, what is urgency now?
urgency is because they are proceeding with the matter. Kindly, my lords, on Monday, if not tomorrow,
Which year is that?
fresh matter.
Fresh matters, all fresh matters, office objections complied, they
Yes.
will come in the list.
Yes, my lords.
They will come in the list, don't
It-
worry.
My lordship.
Yes,
It may
My
be-
lordship,
it is
matter, my lord.
family court matter, my lordship. Maintenance is not awarded to wife. Hence, there is,
fresh matter,
no, my lordship, 20 matter. Service ella complete agide.
we'll see, we'll
My
see,
my lords,
yes,
without.
we'll
memo-
see.
My lord,
without
23
memo,
matter, my
take,
lord.
lords.
Office objections have been complied.
Court office.
My lords,
Yes.
without memo, they will not accept, they will not send the file itself, my lords.
That's okay.
Kindly, my lords.
Why is it so? Anita?
No. Memo, they ask for memo.
There are standard instructions, the moment you comply with the office objections, it has to be listed. They can't even keep it a day in the registry. It has to be before the
Yes,
court.
my lords, may I request, my lords?
If that is the case, look at her, they take that memo and find
Yes.
out from the
Yes,
registry
my lord.
why they have not
Yes.
passed.
For the respondent number 3.
Huh?
Respondent number 3, I'm appearing.
Hmm.
22 matter.
roster is not.
GMFC.
Not for,
In this matter, the petitioner got a stay, but he's not paying any interim order, any maintenance.
Hmm.
There is.
Wednesday, yes.
23 matter, my lord.
Huh?
23 matter.
Huh.
Appellant and respondent are mother and son. Son is trying to evict his mother from scheduled property. And is trying to construct, so kindly.
Take that Tuesday. Yes. These were the adjournments.
Page wise adjournment, page 1, cell number 2, page 2, cell number 3 to 6.
6, your lordship.
Petitioner,
I'm for the respondent. There is another petition filed by the husband. This is the,
I am for the wife.
Hmm.
and it has to be tagged along.
What is the number? Give the number.
18516 of
On
2020.
Monday,
On 13th, it has been listed
it's going,
before this court.
The husband's petition is listed
This
on 13.
13.
it can come on that day. Yes, post along with so and so.
Sorry, sir. Day number.
Yes.
Cell number, page number 3, cell number 7 to 12, page 4, 13 to 16, page 5, 17 to 20, page 6, 21 to 24, page 7, 25 to 28, page 8, 29 to 31, page 9, 32 to 35, page 10, 36 to 38, page 11, 39 to 41.
41, my lord.
Hmm.
Lord, I have served the copy to the trial court advocate personally, but the Honorable Court issued the hand summons. I have served the copy to the trial court advocate, my lord. So therefore, one more notice may be issued, my lord. I'll serve the notice to the trial court advocate. My lord. But this Honorable Court has issued a notice by hand, my lord. Well, I was under the impression that I should serve the notice to the personally to the advocate. I served it. So I request the Honorable Court may issue and summons again, my lord. I'll serve the notice.
41, the counsel for the petition is permitted to take out hand summons on the counsel for the respondent for the trial court and shall file a memo to that effect. Pose this matter after a week.
Interim order may kindly be extended, my lord.
Interim order earlier granted is extended till then.
Publish.
Yes.
Madam, 42nd matter,
Hmm.
I have served a copy on the other side.
Right.
name also is when it's shown.
Hmm.
32.
I am for the respondent in this case. In this case, my lord, they have misrepresented before the honorable court. They have stated that 3 lakh rupees is paid to the respondent, but they have
We'll
not.
hear it if there is a
May
misrepresentation.
see tomorrow, till tomorrow, my lord. 2:30, I got little inconvenience.
32 tomorrow.
Much
Yes.
right.
Cell number, page number 13, cell number 46 to 48.
My lords, serial number 47 and 48, senior is out of the station. so-
My lord,
oppose
one
this
submission, my
adjournment.
lord, with respect
I
to
oppose this
47,
adjournment,
48.
Your Honor. Already
Yes.
sufficient
My
take.
No, 47, 48, one submission, my lord. My lord, I'm
Please.
in Vijayawada, morning, my flight has been cancelled, my lord. Now the flight is by 11:40, my lord. Kindly have it tomorrow or Monday, my lord. It's very, my morning flight has been cancelled, my lord. I'm
Already-
extremely sorry, my lord. I'm in Vijayawada, my morning flight has been cancelled, that's why I sent my colleague. It unfortunately cancelled, my lord, morning flight. I
already
came
they
for
have
my
fixed-
cousin marriage.
they
Kindly
have
have
fixed
tomorrow or
the
Monday, my lord.
date,
I'm
Your
asking
Honor.
only tomorrow or Monday, madam.
They have fixed the date, Your Honor. They have.
No, no, no,
They
no.
have requested.
We are not fixing.
Yes, yes,
The
Your Honor.
flight
They
has
have
been
requested
cancelled.
the
That is the
today
reason
date
only, my lord.
and engage the senior counsel, Your Honor. I
We
have
are also
already
engaged-
engaged the senior counsel today. Kindly
We are
pass
also
over.
engaged senior counsel, my lord.
Today,
It's
today I
very,
will, today I will argue it and tomorrow.
You argue, we'll hear you today. We'll see. Yes.
Yes, you.
my lord,
Page 1,
tomorrow or
Other
Friday, my lord.
matter, cell number
Sir,
1,
tomorrow,
Anas
Monday.
Kumar.
We will hear him. Tomorrow we'll hear you. Let your colleague be
Great.
here.
Oh, great, my lord.
My lord,
This is matter, my
And-
lords.
is not agreeing for this person. He has, is apprehensive. Any other person he may suggest.
Who
He will suggest,
another-
my client will suggest, my lord, if some time is given, he will also find out.
Already apprehensive about it, even before you're suggesting.
My lords, what has happened? I have not taken this
Yes,
name
my lord.
from my client.
What he's saying
My
is-
client is not from Mangalore. He is from West Bengal. Therefore, my lord.
Both of them from West Bengal.
Yes,
my lords.
my lord.
What has happened, my lords? I have not taken this
One
name
submission, my lord.
from my client.
Let any person from Nimans be appointed, my lord. My client is.
But you have to come every time. The girl has to be brought. How is it practically possible? It will not happen in 1 or 2 sessions. It takes a longer time.
During winter, this Dasara vacation, my lord.
That is another 2 months.
No, my lord. September. October.
What is this, my lord?
If some
I
time is
have-
given, my client will find out some person, my lord.
My lords, what has happened? I have not ascertained from my client.
So what are his apprehensions about
My
the
lord,
doctor?
they know that person.
So what has happened, my lords? I have taken this, my lord, from DHO, not from my client, my lords. This name has been come from the DHO, my lord. This is a message where, my lords, I received from DHO. I have not collected from my client this name.
My client will also find out, my lord, because
Because
it's
there are
too short
only-
a time. Yesterday.
He's the
not
only
from that
person, my
place.
lords,
His sources are limited, my lord.
pediatric neurologist there, my lords. And another name is there, Priyanka Prabhakaran. But my lords, qualification so far as pediatric is concerned, my lords, but she's also experienced. Any name, my lords, I leave it to my lords.
What about
Client
the
will
other
also
lady?
find out, my lord.
What about that other lady?
He doesn't know, my lord. He doesn't know. Today it is being
No, just
suggested.
because wife has suggested, council has suggested, let him not have his apprehensions that.
My lord, he will, if time is given, he will find out, my lord. My lord, one submission, my lord.
Yes.
So far, my lord, the order of visitation right has not been obeyed at all. At least in the presence of an advocate commissioner, let him have the
Not Saturday,
pleasure of
anyway, my lords,
visiting the.
Saturday, my lords, in the evening in the court, my lords, that is the order. On that day, we'll keep present on the Saturday.
It's
that
2
is the
years,
court.
my lord, that all.
That's what he's
We
saying.
have bought a child on Saturdays, they have not turned up, and this Saturday I'll keep
Let the
present child
mother
in the
be
court
not there and,
premises.
In the presence of the advocate commission, he will pay the,
Court,
pay the
in,
cost, my lord.
No.
in the court premises with
but
mother,
this
my lord.
particular facts, what she has stated about,
In the presence of the advocate commissioner, my lord.
why, if mother is not there, that girl won't even meet the father.
Father. That is the.
What I understood from the interaction. So let her be there, let him see her.
At least in the presence of the advocate commissioner, my lord.
Madam, can I?
So that no allegations are made.
Well, I'll do one thing, my lord. Let both the councils of the trial court be present and mother will also take the child. Rather, my lord's appointing commissioner because it's again one more order.
This, on the last occasion, this matter is adjourned. For the purpose of getting instructions with regard to the child counselor at Mangalore. Then counsel for the respondent wife had come up with a name of one doctor, which according to the Land counsel, the petitioner submits that the husband has no confidence on the doctor. And it is submitted that they'll also come up with some name. It is submitted that the father never had not met the child. Let the father, it is also submitted that the father wants to meet the child if the mother, if considering all the allegations that are made in the presence of an advocate commissioner, considering all this court deems it appropriate.
Can I speak?
You can tell him considering all this court deems it appropriate to direct the mother. This court deems it appropriate to permit the father to have visitation in the court premises on Saturday between.
Last time, please, 1 minute. Last time the court itself.
This is not a trial court. Unless and until the court wants, court will not speak to you. You can tell your advocate, you have engaged in advocate.
What he wants to
Yes.
submit, my lord, last time a counselor was appointed, she did not obey at all. She didn't cooperate with the.
That we will see, let him forget about what has happened earlier. In the presence of both the advocates in the trial court, the father can exercise a visitation between
3:30 to 5 o'clock. No?
between 3 to 5. Pose this matter on Tuesday. Yes.
Number 2, Raja Rajeshwari TS, cell number 2.
Here for the respondent in this
I
case.
am for the petitioner in this matter, my lord. This is the custody matter. And in the custody matter, I am for the petitioner father here. And the mother had filed for the custody in the lower court, your Honor. Suppressing the fact there is a foreign judgment, the summons was also issued. And subsequently, after me coming on record, I have filed a rejection of petition.
What is the rejection that is dismissed?
Yes, that is court dismissed.
Hmm.
The facts is that, my lord, the petitioner herein is a,
No, it is a mixed question of fact and law.
yes, my, yes.
So at the threshold, it cannot be done.
No, my lord. There is a foreign judgment, US
That is
judgment.
true.
Yes,
So many
my lord.
aspects, they have their own case, they have to file their written stay. Looking at the plaint itself, it cannot be
My
decided.
lord, I have filed my objections in the lower court. And I've also, she has also led the evidence, and the stage now is for cross-examination. My contention before this court is detailed inquiry is not necessary since the foreign judgment is conclusive. It was held on merits after the evidence was done by the petitioner therein, your Honor. Now the question is like when she was issued.
She has not contested that matter.
Pardon me, my lord.
She has not contested that matter.
She had issued, the fact is, once she had been issued with the summons, what she has done is she has sold all her things, including her car, and she is also has a lot of credits there. She happened to fly from there to India in order to avoid the procedures there in US, your Honor. And when she filed here, she has suppressed that there is a case pending in US. She could have as well filed an anti-injunction petition there, training the husband, the father therein to contest the matter. She didn't do that. Nor still today, she has come for that filing of a suit to declare that foreign judgment is null and void. Even in the petition, she does not whisper anything about.
No,
that-
it may be her case that she is not aware of it.
No, she is well aware. My lord may kindly see the.
That is your case.
No, my
by
lord.
filing objections, you're coming up with all these.
My
No, the
lord.
court cannot look at the objections.
No, my lord may kindly see my document, which is 49, my lord. The page number 49, which is the financial disclosure filed by the respondent herein in the DV case, wherein in page 56, she tells that she has received the summons.
Hmm.
She is of the knowledge that there is a case pending, my lord. And that has become conclusive there, and she has not gone for the appeal there.
Please tell the court, looking at her her own objection or the plaint or her petition before the court, can the court reject the plaint?
My
Is
lord,
reject-
yes,
reject the
my
case?
lord, even otherwise also, my lord may kindly see her petition which is marked as,
No, for that, what the court has to
she has
say.
not told in the petition about the jurisdiction, how this court, Bangalore court has a jurisdiction.
Are you on the point of, under order 7, rule 11,
Yes.
which provision you're
Order
seeking
7.
rejection?
Order 7, rule 11, my lord.
Not 11, 11 has the ABCD.
Yeah.
Yes, yeah, my lord.
There's nothing mentioned in the provision.
I have not
They have
mentioned
only
that.
mentioned order 7, rule 11. There are
11.
4 subsections and it's not a suit for rejection. Under section 9 of the GNWC Act, child where it resides, that's the provision. And that's what the court, while rejecting, has relied on a landmark judgment of Supreme Court, where it specifically says where the child resides. That's the
Ordinarily
jurisdiction.
rejected. Under which provide, the provision, your case falls, please tell the court.
It should be A, my lord.
Hmm?
It should be A, my lord.
That you should have mentioned before
Yeah.
the court.
There's no mention of it.
That even the wrong provision mentioned can
Not,
be.
not wrong provision. What is that you want the relief that you should tell
My
them.
lord,
Where the suit appears from the statement
My
in the
lord,
plaint to be barred by any
175.
law. Which law it is barred?
My lord, 175, I have filed under order 7, rule 11, where I have prayed before the court, lower court, to reject the dismiss or reject the above petition as not maintainable in the interest of justice and equity, my lord.
Hmm. So now
So,
let us
my
look at
lord,
No, no.
even in the
No,
petition.
no, please wait 1 minute.
Yes, my
Come
lord.
to the petition. And in the petition, where is the mention about the decree that is obtained by you
My
and
lord,
other
I am,
things?
no, I am for the husband. They were supposed to, that details. I am for the father. Father has taken the judgment in US court. The mother has filed for the custody in the lower court suppressing.
You have to understand,
Yes,
you are
my lord.
arguing on the merits of the matter. You have to argue the matter on the scope of an application filed under
Yes,
order 7, rule 11.
yes, my
How
lord.
can this be decided now?
No, my lord,
Please tell the court when deciding an application under order 7, rule 11, court has to look at the entire evidence, the entire, your objections have to be looked into.
no, my lord. My contention is, my lord, in the petition, what she has filed before the lower court, she has not mentioned the jurisdiction, how this jurisdiction has come, Bangalore to be the jurisdiction, because they had never lived in Bangalore. And she also tells in the pleading that there is a complaint even in Chennai.
There are two separate stands you're taking. One is about a foreign decree or judgment.
Yes.
And as such, this GNWC is not maintained.
Yes.
That aspect cannot be considered in a petition under order 7 to 11. Then you're coming to the issue of jurisdiction. Where is your affidavit, let us see? That IA, that is for, that you filed in support of
Yes.
that petition? Page number?
Page number, my lord. Page number 175 is my application, my lord. And even in the main objections, I have spoken about the jurisdiction that this Bangalore court.
If it is a jurisdiction, will it fall under any of order 11 A to D? Question of jurisdiction?
No, Your Honor.
Then
No, even otherwise, my contention is regarding the foreign judgment, which is a
that I heard,
conclusive,
I have a. that I
conclusive,
don't-
my lord.
That now on that
Just
point.
to mere she getting the child to Bangalore, that cannot be an ordinary residence of the child.
That
the child-
jurisdiction issue will be decided by the court during the course of trial. That can't be a case for a rejection of plaint.
My lord, there is one judgment. the same sort of situations
Yes,
where the father as well happened to file rejection of the
mm,
thing. And it was told, my lord, it is
Hmm.
held that, may I read, my lord?
page number, para.
It from 241, that is the second page, right back of,
The relevant.
yes. The appellant had filed application for divorce and custody of minor children in the US court, and the order came to be passed by US court. Despite the interim order, the appellant came to India and within 20 days of her arrival in India, filed an application for custody of minor child in the family court in India, concealing her application for custody filed in US court. She is also not disclosed that an order came to be passed by the US court against her. In the given facts and circumstances, the opinion of the High Court that the minor children were not ordinary residents of India as envisaged under Section 9(1) of the Guardian and Wards Act 1819 is upheld. Resultantly, the application for the custody of the minor children filed before family court in India is rightly rejected by the High Court in exercise of power of 7 Rule 11 of CPC. At the same time, when the orders have been passed by the US court, the parties cannot disregard the proceeding instituted before the US court filed at the instance of the appellant who is opposed to participate in those proceedings. The child rights may be limited, but they should not be ignored or eliminated, since children are, in fact, persons wherein all the fundamental rights are guaranteed to them, keeping in the mind the best interest of the child and the various other factors which play a pivotal role in taking decision to which the reference has been made, taking note of the parental autonomy, which courts do not easily discard. It is true that this court has to keep in mind the best interest of the child as a paramount consideration. The observation of the US court clearly shows that the principle of welfare of the child has been taken into consideration by the US court in passing the orders, as it reiterates that both the parties are necessary for proper upbringing of the children, and ultimately the decision of the custody and the guardianship of the two minor children will be taken by the US, which has exclusive jurisdiction to take the decision, as the children happen to be the US citizen. And further, order being passed on the respondent emergency petition with a special release in custody on 9th March 2018, permitting the respondent to apply for the US passport on behalf of the minor children without appellants being the mother's consent. The appellant cannot disregard the proceedings initiated at her instance before the US court, and she must participate in those proceedings by engaging solicitor of her choice to expose her cause. The crucial factor which has to be kept in the mind by the court for gauging the welfare of the children equally for the parents can be inter alia, delineated such as maturity and judgment, mental stability, ability to provide
Not
access.
necessary, relevant paragraph, you please
Yes,
read.
yes, my lord. That's what what they have told is, since the
Ultimately, what is that the Honorable Apex Court said? That is altogether.
it is
arising
told
out of-
that the US court has a jurisdiction because it has the hold on the welfare of the child. My lord, here the child is a US citizen.
NWC is filed in the year 2017.
Yes, my lord.
Now we are in 2024.
Yes, my lord.
So let
yes,
the
ma'am.
court decide it on the merits of it. Please come. The present application is filed. The present writ petition is filed. Agreed with the orders passed in.
My lord,
Item number.
may I make one small, that even the US government is been trying to reach the mother for the welfare report. She is not coordinating properly with the department people also, my lord. Even in the cross examination, she tells that she has applied for Indian passport, and as on now, the child is not Indian, is Indian. But the citizenship cannot be interim, my lord. Once it is a citizenship granted, it cannot be for 5 years. She tells it is for 5 years only, and now she is trying to convert the citizenship of the child without the knowledge of the father. And the father has to give no objection affidavit even for the passport or the citizen. But I think she is doing some mischief there, taking the orders.
We will ask the JNWC court, this is 2017 matter to decide it in 6 months. Agreed with the orders passed in.
And
Number-
my lord, sorry, my lord, until then, a direction may be given that father may interact with the child on Saturday and Sunday, 7 to 8, video chat. They are not obliging, my lord. They are literally
petition,
morally
when
bad.
this
on the
honorable
part
court had
of
done, we
protecting the
had followed,
affinity of the
we have
father.
submitted the video also as
They're
directed by this court.
happily talking, Your Honor, but next Saturday, Sunday, they give,
Let it continue till the JNWC. is-
Sunday,
until
Sunday, 7 and 8.
Yes.
and
every
also Saturday, Your Honor.
The.
Saturday, she is going to school. ma'am.
7 and 8, she has told in the
It is
video, Your
kept
Honor.
quiet right from 2017 without asking anything. Now when the
But
court.
my lord,
My
there
lord,
is a.
not a
contempt-
single rupee has
my
been made, my
my
lord.
lord,
If
there is
they
a
are so much
contempt-
insisting, my lord.
there is a
One thing I would say,
contempt application pending.
2016 onwards, since I was made to flee from US, not a single rupee has been.
She has not filed any.
On a
maintenance
birthday, he'll send a small
application.
toy through the website, he will send. Apart from that, not a single rupee
They
he has
don't
paid.
show the face, my lord.
This is not the
Yeah,
way.
yeah.
Both of you argue what the court can do.
No, she's
Therefore-
not at a file
Then
maintenance
both of you argue, I'll
application.
just listen what's.
They are
happening.
avoiding the summons.
Agreed with the orders passed in. I number. I number 14 or 16.
16.
I number 16 in JNWC number 120 of 2017. Is it recording? Dated 6th July 2022. The mother is, the father is before this court. The facts of the case are the respondent mother had filed GNWC 120 of 2017 seeking custody of the daughter. It is a case that where is a petition?
One 47, my lord. That is C1 and C2.
It is a case that the daughter, she was residing along with her husband in years and they're blessed with a daughter
147 C1.
and as a husband subjected her and her infant daughter to mental and physical abuse, due to which they were subjected to cruelty at the hands of the respondent and the hands of the
That is got
husband.
dismissed, my lord.
He deserted her and moved away, finally left with no other option. She was forced to come to India along with the minor child. And since April 2016, she has been living, she is living along with her parents at Bangalore within the jurisdiction of the court. She is well qualified, employed and taking good care of the minor daughter who is aged 5 years.
Now 13
Now-
years.
What time it is about the petition, aged 5 years, going to a Montessori school. The husband had written a mail to her on 23/9/2016, threatening to take away the child from her. As such, it made her to file this petition seeking custody of the minor daughter. The present application came to be filed. When is this application filed? And where is your affidavit?
310 to
2018.
2018, my lord.
3/10/2018.
In
Page
2018,
Page number
the
170.
husband had filed the present application under order 7 to 11 to reject the petition. Where is the
175.
IA affidavit?
176.
176, my lord.
One
176.
6.
That's a affidavit in support of IA.
76 or 176?
176. ma'am.
176.
176 is a order sheet.
Annexure F, my lord.
second page after annexure F.
You file the present application to reject the petition. It is a case of the husband that the wife had filed this petition seeking custody. It's a suppression and misrepresentation of facts. The daughter is a US citizen and holds a valid citizenship. And this is a place, India is not an ordinary place of residence for the girl. As such, the courts at Bangalore have no jurisdiction. And further, already in view of the judgment passed by the foreign court, the suit, the present JNWC itself is not maintainable. It is a case of the husband that he has filed a petition for divorce and also permanent custody of the minor before the court at Anne Arundel County, Maryland Court, which is a proper and jurisdictional court, and also the permanent domicile of the daughter on 28th July 2017, and the court has passed a judgment by granting decree of divorce and also further ordered that the custody of the child shall be given to the father. The wife was served with the notice of a court hearing in person by a representative. The wife, without contesting the matter, chose to flee from the US and suppressing the fact that the custody is already given to the father and also divorce is obtained. The present petition is filed. It is stated that as this is not as Bangalore is not the ordinary place of residence for the minor, the application is not maintainable further. Already there is an order of the foreign court, which is binding on the family court, and even on that count also, as it is barred by law. And it is not maintainable, and accordingly came up with this application to reject the plaint. The trial court, by order impugned, had dismissed the petition. While dismissing the said petition, the court had observed that
Page 38 is the
Para
rulings relied
15,
upon.
my
by-
lord, 38.
Para 15.
the court has observed that the apex court had held that the court in the country to which the child has been removed must first consider whether the court could conduct an elaborate inquiry on the question of custody of the child to the country from which he or she was removed, leaving all aspects related to child welfare to be investigated by the court in his own country. No, not that. The court had considered the judgment relied on by the father. The court observes that the court is of the opinion that As the mother and the ward are now residing within the jurisdiction of the court, the court has every right to try the matter in connection to the legal custody of the ward in the better interest of the child. Apart from that, at the time of passing of the orders by the foreign court, petitioner and the child were not at all residing in the said country. On the other hand, the interest of the ward is a matter which has to be investigated in the present petition, which is filed before the court in the native place of the ward, where it is now residing with her mother. The court has come to the conclusion that the court has jurisdiction to investigate the matter by way of inquiry into the petition, and accordingly rejected the application filed by the father. Next paragraph. Learned counsel appearing for the father submits that the court has to fail to consider the application filed by the father under Order 7 to 11 in its proper perspective. It is submitted that as per Section 9 of the JNWC Act, the court in whose jurisdiction the minor ordinarily resides at the jurisdiction, whereas in this case, the ordinary residence of the boy is
Girl.
the girl is in yours, but not in Bangalore. The court had failed to consider the judgment of a foreign court, wherein a notice is also served on the wife, and without contesting the same, she has shifted to India, and the judgment is binding on the wife. When that view, both on these grounds, the writ petition is not, the GNWC petition is not maintainable on law as well as on the aspect of jurisdiction before the court at Bangalore, and this aspect was not considered. It is a further case that right from 2017 till now, the father was never permitted to see the child. And after the orders are passed by this court, on the last occasion, he could interact with her on the video call. Earlier attempts, when they tried, the girl used to completely close her face, and father never had an opportunity to see her face.
On he resides in US. He has never come to, whenever he has come to India, the child has spent time with him.
No, my lord.
No, we have videos and he has interacted.
Record your
Yeah,
submission.
yes.
No, my lord.
In April also,
No, that's what I
mother-in-law
read.
had come a lot.
And
Yeah, yes.
Mother had come, not he.
And submitted that the GNWC is not maintainable, and the application filed under Order 7 in 11 has to be allowed. Next parallel, and counsel appearing for the respondent mother submits that mother has come to India in the year 2016.
No, recently also she happened to come, Your Honor, like.
No. When is that? As per the petition, 2016 she has come.
Yes, ma'am.
In the year 2016, she has come to India.
Mother of the child.
She has come to India as the mother and the daughter were both put to mental and physical harassment by the husband, and having
My
no
lord,
other option.
The petitioner had come in April 2016.
That is not relevant. What is relevant is
The
and
petitioner, sorry.
What did you write? Having no other option, she had to file a petition. And she had to come back to India. And when there was a threat from the husband, she had to file this petition seeking custody. As on the day when the petition is filed, the girl and the mother are residing within the jurisdiction of the court. And the court had jurisdiction to entertain this petition. It is submitted that with regard to the binding nature of the foreign judgment and other things, based on evidence, whether notice is served, whether she has contested the matter or not. All these issues have to be decided by the court after a full-fledged trial. At this stage, at the threshold, on an application filed under Order 7 to 11, the petition cannot be rejected. Next para. It is the contention of the land counsel for the respondent wife that the earlier, when he has come to India, the father had interacted with the child, and it is his case that except asking filing these kind of petitions right from 2017. He has not taken care of the daughter, nor he has contributed anything for monetarily for any of the expenses of the child. Then counsel appearing for the petitioner had denied the same and submits that the father never had an opportunity except with the order passed by this court. Next para. Having heard the counsels on either side, there is the material on record. The respondent herein, the mother, had filed JNWC petition seeking custody of the minor child.
There is one DV as well as one divorce petition.
The child. That is not relevant to this. If you don't allow the court, there is no continuity.
Sorry, my lord.
It
I
is
thought
required, I'll ask your assistance.
Sorry, my lord.
Yes. The JNWC petition seeking custody of the daughter. The undisputed facts in this case are the father, mother, and the child were residing in the US till 2016. And it is a case of the mother that because of the disputes arose between the parties, and also it is a case that as the husband has abandoned and he has harassed her, she has to come to India, and she is in India from the year 2016. It is also not in dispute that the girl is residing in US. The girl is a US citizen. The girl is a US citizen. Now it is the case of the father that the courts at Bangalore have no jurisdiction, and this is not the ordinary residence of the girl. And also that the foreign judgment where he was granted divorce and custody of the daughter is binding on the Indian courts, and this petition cannot be entertained. This also the counsel for the petitioner relied on a judgment of the apex court in case of Lahari Sakamuri versus Shoban Kodali. Basing on this, it is submitted that an order application under Order 7 Rule 11 is maintainable. Before going into the merits of the matter, it is appropriate to look at Order 7 Rule 11, which deals with rejection of plaint. Extract Order 7 Rule 11. According to her, she falls under D, where the suit appears from the statement in the plaint to be barred by any law. While considering an application under Order 7 Rule 11, the court has to necessarily look at the plaint oblique petition, and court cannot look at any other evidence. Now, in this case, she is relying on the judgments, there are several documents that are filed by her, and all those aspects have to be gone into for deciding this application. In the considered opinion of this court, that's not the scope of a petition under Order 7 Rule 11, and the court cannot look into any other document than the petition. And looking at the petition, it do not demonstrate that it is barred by any law, or it is, and the courts at Bangalore do not have any jurisdiction. All the contentions that are raised by the petitioner have to be decided by way of a full-fledged trial, where the issue with regard to the jurisdiction and the binding nature of the judgment of the foreign court have to be decided by framing issues and also by using the evidence. But at the threshold on an application and under Order 7 Rule 11, it cannot be decided. The contents and the points that are raised by the petitioner further are beyond the scope of Order 7 Rule 11. And further considering the fact that the GNWC is filed in the year 2017, and it's already been 7 years. Considering the same, this court deems it appropriate to direct the trial court to dispose of the GNWC itself within a period of 6 months from the date of receipt of the copy of the order.
My lord, 8 months,
Considering
because for evidence, at least 1 month, he needs a protocol, everything to be done and come, Your Honor, for him.
You don't want it to be disposed of early?
On 4 occasions, she had already cross-examined thoroughly.
Huh?
1 month extra, maybe 9 months.
Decided within 1 year.
Yes.
Within 1 year from the date of filing of the application, from the date of receipt of the copy of the order. Second, as per the considering the fact that the father was not able to meet the child and no, the mother shall, the father can, speak to the daughter through video call on every Sunday. between-
Evening 7 and 8. That will be
Between,
morning for him then.
between 7 and 8. At
But
any
Saturday, my lord.
7 and 8 PM.
7 and 8. Either if it is not possible on a Sunday, some other day in weekly once that has to be compensated. At any point of time, if the order of this court is not complied with by the mother, the same shall be brought to the notice of the trial court, and the trial court shall pass appropriate orders.
My lord, one submission, my lord. Let the mother cooperate with the welfare report, US Council at Chennai. They have been.
Don't ask her too many things before this court.
53.
Yes.
One more,
Ananya
my lord, I filed the same petition
Will
in
not
the,
add.
one humble submission, my lord. I filed the same petition, application in the divorce and DV. Let this not affect that application, my lord,
Which
because
application?
the same rejection I filed in the divorce and
When you see such kind of a relief, at least I can understand if you're saying
my
that.
lord, the domestic
Please
violence.
understand, you're all, everything you're asking beyond the scope of the writ petition, beyond the scope of GNWC. No, you can at least, if you ask the court saying that these observations shall not affect the,
Yes, ma'am.
you're in the, during the final hearing, but not for in other proceedings. Yes.
Serial number 3, Ananya Rai for petitioner, Manjula Kamajoli.
I appear for respondent in this case. Yes. Where is the petitioner?
I'm for the petitioner, Your Lordship.
Yes.
The petitioner is the husband and the wife is the respondent.
Hmm.
I have filed an MC case on the ground of cruelty.
Hmm.
During the proceedings, Your Lordship, maintenance was claimed by the.
What is granted?
8,000 is granted.
Hmm.
And then challenging the same, I have filed a.
What is the interim order of power passed by this court?
Is to stay the grant of. maintenance.
Conditional order might have been passed.
No, Your Lordship, there's no conditional order.
Simply
It's-
stay.
It is stayed because I have shown to the court that she's also a dentist. I am also a dentist. She has occupied my dental clinic. I have no means of going off work at all. In fact, she has also occupied my house.
Please come to the order.
Yeah. So, yes. Annexure A, Your Lordship. Reasons start from page 13.
Yes.
Order is.
Paragraph number 8 may be read by. Yes.
Paragraph number 8, my lord, last 3 lines. The counsel for the respondent has filed the copies of the notices issued by the health department to the respondent. Reply given by the respondent on page number 5 of the order, my lord. Her application for renewal of the license is, my lord, rejected, and she has not renewed the license since 2018.
Why you are not renewing the license?
My lord, she is suffering from mental disorder and, my lord, nervous weakness, my lord. I have produced the documents, my lord. Along with my statement of objections, I have produced the documents. The same is observed by the trial court. In paragraph number 8 of the writ petition order, it is stated.
Yes.
That the counsel for the respondent has filed the copy.
Yes, I have seen. What do you say?
Your Lordship, it's a very interesting submission to make that the license has been revoked. Revoking of license is not proof to the fact that she is not practicing. I will produce documents in this regard, Your Lord. Sir.
The new documents cannot be filed now. Whatever she has filed along with the writ petition can be perused. And I have filed the documents which are produced before the trial court.
Your Lordship, I will show what kind of documents these are, and then it can be decided whether I could have produced this earlier or not. Your Lordship, these documents are proofs to show that she is practicing in my dental clinic. Your Lordship, on page 2, Your Lordship, 2 of the memo for production of documents, I have produced 2 photographs of the board that is in the.
Board is there, but
Please
she is-
come.
Your Lordship.
The respondent, it is a contention of the petitioner that the respondent is a dentist and she is not entitled for maintenance. It's a case of the respondent wife that she's suffering with the mental issues, and as such she is not practicing. By the next date of hearing, the respondent shall file an affidavit before the court that right from the day she has filed an application before the trial court.
My lord, before
Till-
that, my
till today-
documents produced along with statement.
No,
of
no, I'm
objections
not
will
saying
be
anything.
considered.
Please listen to the court order. Right from 2019 till today, she is not working. She never worked or she is not working and she is not having any income. They're basing on that, the further orders will be passed. And by any chance, the statement that is made before this court is on oath is not a correct statement. Appropriate proceedings will be issued against the
My lord, your lordship may
respondent.
kindly, first, my lord, your lordship may kindly see the annexure, my lord, R3. I produced it along with my statement of objections, which states, my lord, that the district medical officer has issued this certificate.
So
my
that
lord.
I have read the order. Give it to her. Yes, when can you file an affidavit?
Next week I will file.
Next week. Post this matter on Wednesday.
Your Lordship, interim order may be extended.
Interim order earlier granted is extended till then. Yes.
Serial number 4, admission. Badrinatha, for appellant. K.S. Harish. For respondent.
Give the file. What is the suit for?
My friend is.
Yes.
For the appellant, just for money recovery,
For
money recovery.
money recovery suit. What is the IA?
I have filed an application, 2 applications had been filed.
Hmm.
Order 39 rule 1 and 2 not to alienate the property. Order 38 rule 5, security or attachment of the property. Both the,
Before judgment.
yes,
Um,
both the application came to be dismissed. Now, only on the principle of Order 38 rule 5, where the trial court itself has not considered Order 38 rule 5 integrants of the reasoning order. May kindly look into only the reasoning of the trial court, para number 20 and 21.
There is a stay in this.
Huh?
There is a stay.
Uh,
Stay.
Before the trial court, I was, at the first instance, there was the interim order. not to alienate the property.
And if the property is granted by this court.
Not this court, before the trial court.
Hmm.
Before this court, I don't have an interim order.
Now, my lord, the trial has.
You are the defendant in the suit.
No, I am the plaintiff.
Then your application must have been dismissed.
I have been dismissed.
And then you have come before this court.
Yes, ma'am.
So what is the stay?
I am seeking for attachment of the properties are 38 rule 1 and 2.
No, that I understand.
Ma'am, same
What is
application had been
What
filed.
is- What is the interim order that is passed?
No, interim order has been not passed by before
That is
this.
what I'm asking. So
Before
what
this
is the
honorable
statement of the suit now?
No,
2000.
it's posted for evidence of plaintiff, defendant's plaintiff cross examination tomorrow is there.
Hmm. So now for that order 8, order 38 will file that petition, considering it now at 2024, what is?
Madam, by the
purpose
time
of-
now, from the date of filing the year 2017, at their instance, the matter has been adjourned.
No. It is not about why it is adjourned or the delay. Now the thing is, why an application will be filed?
Madam, only to protect my interest, that's all. Now, if that gives any security to the court, I have no objection. Now, if this application is out, my amount is huge amount is there.
You were saying your apprehension is, he is
I
going to
defeat my
sell-
right.
he is going to sell away those properties.
Now, by the time already 30% of the properties has been sold.
No, that your properties are sold.
Lord, some of them are my property. There is clear cut finding. There is no loan transaction. Lord, whatever amount is paid, my
Are you
lord.
denying any of that money transaction between you?
Yes.
and the- According to you, you have not received.
There
the
is no absolute, not a single paisa, my lord. I have produced documents to show for the amount that he has paid in that company whom he has not made party, he has received shares. For the entire amount of 12 crores that he has paid, he has received share and he has not made them a party. My ground is misjoinder and non-joinder of parties. That is one of the grounds that I have raised in the written statement.
To consider the interim application, that is not a ground here.
Yes.
I'll may kindly look into page number.
Para 18.
Please read para 20.
20.
Para 20.
Upon perusal of the plaintiff argument shows that the plaintiff claims that he paid the loan amount to the defendant one.
Para 20, page number 33.
20. In the light of the arguments are canvassed by the respective counsels for the parties, I have gone through the record. Admittedly, this is a suit filed by the plaintiff for recovery of the money against the defendant. The plaintiff has filed IA-2 under 39 Rule 5. That is mistaken. That should be 38 Rule 5 for attachment of the landed property shown in the application. So he filed an IA-3 seeking a allocament of the order of the injunction against the defendant not to alienate the landed properties shown in the application. It is the contention that the plaintiff is in view of the close business relationship with the defendant, and he had paid an amount of rupees 14 crores 27 lakh 50,000 to the defendant one, and out of which the first defendant had repaid a sum of rupees 1 crore 86 lakh 15,000 through the check, thereby having a balance of 12 crores 41,000 35,000. The plaintiff came up with these two applications mainly on the ground when that the defendant one is in a due to such a huge sum of amount. He is making all kinds of hectic efforts to dispose of the landed properties. The item number 1 to 21 as shown in the application, it is the main contention of the plaintiff that the loan amount advanced by him is the defendant one was utilized by him for the purpose of purchasing the landed properties as shown in both the applications in his name and also in the name of his wife and the company. Admittedly, the defendant two is none other than the wife of the defendant number one. The plaintiff is in order to establish his contention that the defendant one is making hectic efforts to dispose of the land's landed property is shown in the application as produced by some of the sale agreements with the came to be entered into the defendant number two, which is the wife of the defendant number one, with the third parties by manipulating the property numbers. So also he has produced some sale deeds to show that from the loan amount given by the defendant number one, he had purchased the landed properties in the name of the defendant number 2 to 4. Most important aspect to be taken into note that that the plaintiff has produced a loan only some sale agreements alleged to be entered into between the defendant number 2 and the third parties, and same sale deeds, but the basics of the said documents cannot be possible to say that the stage of the defendant number 1 from the alleged loan amount by the plaintiff. He has purchased the loan property shown in the application in the name of the defendant number 2 to 4. The defendants have produced the memorandum of understanding entered between the defendant 4 and 2 at the document number 5 and memorandum of agreement entered into between the defendant 2 and 3 at the document number 8. They have the very document number 12 is the income returns produced by the defendant number 3 for the year 2008 and 9 and 10. Show that the stage of the company had sufficient source of.
Cited this application as a 1 under order 39.
Yes.
But both are there. Both applications are there.
No, that is true. This IA number 3 is attachment.
That is also there.
Rule 5.
Blood, what? Yes.
As far as that is concerned, so speaks about prima facie case, balance of convenience, irreparable loss. The exercise should have been not like this.
But fact remains, blood, even for 38 Rule 5, that prima facie case, because very fact not 38 Rule 5
That
requires.
is not considered there. That the prima facie case, according to the court, is something else. Will you please come to page 38?
38.
So also perusal of the materials placed. That is
So also
about,
perusal of the materials placed
uh,
before the court by respective parties clearly shows that at this stage, the plaintiff has not made out prima facie case to grant the relief sought in IA number 3. And even the materials on record at this stage also does not disclose the balance of convenience lies in favor of the plaintiff. When that would be the case, it is needless to say that no hardship would be caused to plaintiff in relation.
now what should be the finding of the court? Now he is seeking attachment. So whether it is attachment is required or not in the facts and circumstances should be the finding. Now,
But
according to him, like you are going to dispose of the properties. Once that is disposed, then even if in case a decree is passed also, he can't record the money is his case. So further, there should be a finding on that.
But
Saying that whether it is that or the not
that
That
now
the
that my
application
lord
is
is
reconsidered by the trial court.
my that
at this stage.
now that my ladyship has pointed out.
Let
this
him
para
undertake
22.
undertake to produce a certain security before the court.
Para 22, your ladyship has just pointed out. My lord. Now that I see, my lord, prima facie case, your lordship would agree with me that even for 38 rule 5 is required, because 38 rule 5, my lord, envisages, my lord, issue of notice before passing that kind of an order. That means, my lord, application of mind. My lord, what the learned trial court, learned judge of the
No,
trial.
what is the scope of an inquiry under 38(5)?
38(5), my lord, it has to be, my lord, balance of convenience also should be there. My lord, my prima facie case should also be there. My lord, the court should come to the conclusion that if the plaintiff is likely to succeed in the suit, my lord, there is something which is available. My lord,
That is, if not, it is succeed, like we won't do a roving inquiry under 38(5).
38, yes. Absolutely. But that is there. But anyway, now that my lord asked this question to my
No,
friend.
according to him, there are some properties and the court never gives a finding that on the face of it, the transaction doesn't appear to be genuine or whatever that material as of now at this point of time do not show that there was no transaction.
Yes, para 18, it.
Your
Yes.
case is that
Yes.
you also do not deny the fact that there is that there is no transaction.
Lord, yes, Lord, I have placed materials, Lord, clinching material before the trial court along with my written statement where the amount transferred by him is not shown in the balance sheet of that company as share application money, and next year it is share application money shown as zero because he has become the
see that.
shareholder. Lord, written
Those
statement.
aspects in the written statement which have been not considered.
Court
Document of-
somewhere speaks about the.
Courts
balance
only
sheet.
speaks about 39 rule 1 and 2, not again 39,
First-
38 rule
See
5.
that, we will see that basing on now when it has come before the court.
Lord, first para 16 to page 16, Lord, of that, your lordship is having written statement of D1.
No,
But,
written statement 1 to 14 is written statement.
Yes, Lord. And document number 1, Lord, is
No,
the
in the written statement, which para you have mentioned about this?
transaction, Lord.
That
Yes.
it is already now,
Lord, the whole of, this is what even the trial court has referred to, para 2, and thereafter, Lord, sub para 1 to 10, sub para 1 to 10, para 2, sub para 1 to 10, the entire transaction I have explained, Lord, in brief. Written statement at ink page 2. Lord, may I take, Lord, para 2? The defend number 1, your lordship
Yes.
is at sub para 1, Lord. The
Yes.
defend number 1 and 2 here, husband and wife, their marriage having been solemnized in the year 2001. The plaintiff herein was close friend of one Mr. G.K. Senthil Rajan, who is none other than the brother-in-law of the defendant, and hence the acquaintance of defendant with plaintiff only through Mr. G.K. Senthil Rajan. Post his marriage with defendant number 2. This is pertinent to, it is pertinent to mention here that plaintiff and defendant have since developed a very close business relationship between them. During the year 2008, defendant number 1 along with defendant number 2 promoted a private limited company known as G7 Private Systems with a share capital of so and so. Copy of the memorandum articles is document number 1. Shortly after the incorporation of G7, the plaintiff herein volunteered to invest in the new entity, and commencing from May 2008, the plaintiff.
can come to 4.
Yes. In the light of the above developments and change in the management of G7, the plaintiff had a series of discussions with G.K. Senthil between March and November 2010, and thereafter came up with the request to D1 to treat his advances in G7 as share application money with G7. Shortly thereafter, plaintiff forwarded a pre-dated draft letter to be sent to D1, addressed to the board of directors of G7 for treating sum of ₹12 crores, which includes the advances of D1 with G7 systems as share application money, as per the requirement of plaintiff's auditor. Copy of this email along with so-and-so document number 4 and 5. It is relevant to mention here that though the advances made by the plaintiff to the defendant number 1 are, as on the relevant date was far lesser than ₹12 crores, the plaintiff assured to pay the differential amount in due course, and D2, considering his business relationship with plaintiff, readily agreed to for the same in good faith. Based on the above understanding and acting on instruction of plaintiff, D1 duly submitted a request letter dated 31/3/2010 with board of directors of G7 to treat the advances share application money. The fact that D1 had advanced the money received by him from the plaintiff with the G7 systems is evident from the statement of affairs of D1 for the year ending 31/3/2010.
Let's see document number 7.
Document number 6 and 7, Lords. The Lordship may kindly come to 6 is at page 46.
6 is at 77, I think, as per the number.
Lord. Your Lordship has a subpara 5, Lord.
Or this documents I'm referring to.
Written statement of the defendant number 1.
Uh,
Your Lordship is
this
at
is
document number 6 and 7 at the subpara 5. Subpara document
Please come to 46.
46, Lord. Statement of affairs of D1.
Yes.
Here your lordship will see
Hmm.
page 46, document number 6. But this is, your lordship will see this 12 crore 66 lakhs 672 on the right hand side, my lord.
Advance to.
Advance to G7 Systems Private Limited. That is, my lord, the company which is not made a party to this list, where, my lord, the plaintiff would get the shares. Next document, my lord, document number 7.
G7 Systems is the plaintiff.
No, my lord.
Hmm.
But G7 Systems is a company initially promoted by D1 and the brother-in-law of D1, that is GK Senthil Rajan, Mr. GK Senthil Rajan. Subsequently, my lord, I have resigned from that board because the company was to be taken forward by plaintiff and Mr. GK Senthil Rajan. I have resigned, my lord. Those resignation documents also I have produced. Mr. GK Senthil Rajan, my lord, takes up the management of the company. But this is the affairs, my lord, as on the 2010. And the balance sheet of that company will show, my lord, receipt of that amount in that company's balance sheet. And next year, my lord, it also shows that the share application has been.
No, where is the name of the plaintiff? Where do you get it?
Not.
This is advanced to G7 Systems.
Yes,
Private
no,
Limited.
that is based on the instructions of the plaintiff. Then,
where
Lord,
is-
kindly come. Yes, Lord, I'll just point out.
Where is that?
Document number 7 is, Lord, Form 23 AC. Lord, this is the balance sheet of G7 Systems. Document number 7. Your lordship will see in the first page itself, Lord, the name of Mr. Senthil Rajan as the director. Lord, this date of signing of this balance sheet is 24/9/2010. Then your lordship may kindly come to about 4th or 5th page later. At page 51. Lord, on top, Lord, your lordship will get part B, particulars of mobilization and deployment of funds. There your lordship will see share application money, pending allotment, 12 crores. That your lordship will see is as on 31/3/2010. Then, Lord, on the right hand side, that is the last column of the same page, 31/3/2009, there was no money there. It came only as on 31/3/2010. That is why it is shown as on 31/3/2010, share application money pending allotment. As on that day, share has not yet been allotted. Then, Lord, may kindly come to the next document. This again, page 53. I request, Lord's indulgence to see that this was submitted on 24/9/2010. These are documents uploaded. Then document number 8, G7 Systems Private Limited. This is the this is what is submitted to the ROC and Income Tax Department also. Table A, number of shares, Gunasekaran Senthil Rajan and his wife. Then this is as on 30/3/2011. Then 30/11/2011, your lordship will see at document number 9, page 53, the shares allotted to the plaintiff.
53.
53. I'm sorry, 55. This is also submitted as on this date of allotment is 30/11/2011. It is shown.
What is the amount?
Your lordship will see the amount is 6,70,000. I'm sorry, the number of shares is 6,76,000. Amount shown is 67,60,000. That is at the rate of 10 rupees per share. Then, Lord, your lordship may kindly come to next document, document number 10, page 56. This is as on 30/3/2012. Date of allotment. G7 Systems, again, this other company, which is not party to the list. Number of shares allotted, 9,50,000. Then at page 60, my lord, table A. This is allotment of shares, form number 2. Then again, 9,50,000. Then, Lord, document number 11. This is the balance sheet of the subsequent year. Earlier year, I showed, my lord, to my lords. About 12 crores is a pending share application money. Now, this document at document number 11, form 23 AC, balance sheet of that company, G7 Systems Private Limited. Now, these are all publicly available documents. That's how I could download and submit it to the court. Date of balance sheet, 31/3/2011. Date of board meeting, 1/9/2011. Here.
In the plaint, does it say about any of the transactions?
Yes. Then, Lord, at page 63.
No, no.
Just for a
Does the
moment.
plaintiff say
Yes.
about all the shares and all in the plaint?
No. He only says he only sticks to loan transaction. He does not, there is no
Because according to them, when was this?
between 2008 and
Money flown into this company?
between 2008 and 13, just for the limitation purpose, It is long drawn out 2008 to 13. I have also taken contention relating to limitation lot in my written statement.
According to him, this transaction is between 8 to 13.
8 to 13, long drawn out. This
Hmm.
entire money which I am showing to my lords, 8, 9, 9, 10, 10, 11 balance sheet itself, the company shows receipt of share application money and allotment of shares at page 65. Just for last indulgence, my lord, in relation to these documents, page 65. This is as on 31/3/2011. This balance sheet is filed. Your lordship will see page 65, share application money now is 0 because it no more remains in the application money form. It is not allocated to the allotment of shares. So, my lord, it does not remain in 2010, 31/3/2010.
This is as on what date?
This is as on 31/3/2011.
According to him, in 2013, what he sent?
No details.
Let's look at the plaint.
Not plaint, my lord, my land fund has filed along with the MFA itself. At page 40, it starts. Para 3 would be relevant for my lord's consideration. The plaintiff,
No details.
No details.
How, when, where? Just defendant paid the first defendant somehow rupees 14 crores and all between 27/5/2008 to 21/11/2013.
those are the only 2 dates available in the plaint in relation to this payment. There's no document, nothing is there.
What do you say?
Where the transaction bid I had paid to the different number 1, where in G7 system is a party before the court below. They are, he is a party. G7, I am the one of the director of the G7. Where the G7 systems has been transferred to the Chendil Rajan and his wife, where they were personal dues with him. Chendil Rajan.
When you're saying that you have paid the money, there should be some,
Through check itself had been paid.
where is that? Where are the details?
Only the plaint had been produced before the court. I can produce the document before the court, which I.
No, plaint should contain. When
No, it's
you're-
there in
when
para
you're
4
filing a petition, along with the plaint, you will file the IA also.
Yeah.
Or then,
Yes.
then where is the IA?
Yeah.
No, there should be. prima
IA
facie
is there.
People should understand that, by way of these transactions, for example, somebody files a suit saying that I've given 100 crores to so-and-so by between so-and-so, and that attachment there should be an attachment before judgment. That is not.
Right.
Court should prima facie, looking at your averments, should show
Kindly
some
look at,
means known to law,
Yes.
you have transferred the money. Where is
Kindly look-
that?
kindly look at page number 55, para 4.
We'll see that. 50?
55, para 4. Shall I read?
Yes.
The plaintiff has on several occasions demanded the first defendant to repay the amount with with accurate profit at the rate of minimum guaranteed and appreciation of 7.5% inflation on appreciation of the properties that the purchasers of the property from the out of the nominees and received by the
Where
first
is
defendant.
document number 24? Document number 24 and document number 25.
Before in this appeal, I had been not produced those documents.
What does it contain? What does it show?
Where
How
it-
much is the amount?
No, it's total, I had been for, amount is due as on a date of filing of the suit, 12 crores due is there.
As per these documents.
Yes. But where G7,
That is what I'm respectful, sir.
I'll complete. G7 systems is where I am the one of the director of the G7 systems. Where Chendil Rajan and his wife were dues to by the different number 1. He paid and he transferred the amounts to Chendil Rajan and his wife
Need to become a director.
In the year 2008 and 9. For 67 lakhs, whatever the amount I had been invested to, that itself has been shown in the share capital, shares to me. Remaining this amount, it has been not reflected in their accounts. Or amount has been transferred to me. May kindly look into Form 32A filed by the company's report with G7 by the different number 1 itself. It's only reflects to only 67 lakhs itself.
No, who are the defendants?
But different everything.
No, defendant,
Jagannathan.
you lend the money to
D1.
the defendant number 1 according to you. No, only one property stands in the name of defendant number one. That is a someone, what is
Item
it?
number 8.
Item
And other
number.
properties are also there.
Ancestral property.
Other properties are also there.
The other property, no, this is the one which is purchased by
Yes.
him. Others are ancestral property.
No. No, where in a suit for money recovery, court cannot decide it's ancestral or self-acquired property.
I'm just asking.
For
I
that
can
itself.
understand that.
Now, these
Item num-
other properties are stands in.
According to you, the prop with your money, he has purchased the properties.
Yes.
For that, I'm trying to understand. Item number 8 is a joint family property, according which
Yes.
is purchased much before you gave him the money.
Mm.
So what are the other properties which are standing in his name, which were purchased subsequent to you giving money? to
After
him?
I paid the money, only had purchased these properties.
Which property?
No, all except item number 8, remaining properties have been purchased.
That are not, which are not in his name.
No, which before it was not there.
No, for the clarity of
Application.
factual aspects. So the other properties are not in the name of plaintiff.
No.
Are in the name of defendant number 2.
After filing of this suit, some of the properties has been transferred from defendant number 1's name to defendant number 2 and 3, and from the defendant number 3 to 1 and 2.
That we will see that there is a finding of the court. Then you made G7 investment company for which you are a director as a party respondent,
Yes.
defendant. Why?
For my investment, I had been as a director.
No. When you're seeking recovery of money from him in his personal capacity, why is this company made as a defendant?
Well, for that itself, for he himself has already kindly look into his written statement of para number 4. He says, based on the oral draft of my auditor, he had been, shared capital has been divided, had been assigned to me. Based on the draft letter he had assigned, what he had shown in the ROC, it has been not reflected.
No. Initially, the company was not a party, or from the company?
From the beginning, it was a party.
No, further I'm saying, initially, when you are saying that you have given the money to him in his personal capacity, why did you make this company as a
The
party?
very company is in, there is a transaction with money. I had paid the amount to the company through
Through him,
myself, through him itself.
please come.
My kindly look to the written statement itself, I'll send. Para number 3, sub para number 3.
Yes, I'll record that. The present petition.
No, only
is-
one
appeal is filed.
more second. I'll rely on only one judgment.
Yes, please pass on. Yes.
Para 5. I'll straight away. Regarding the 38 rule 5, application itself is not considered by the trial court below. Only considers application under 39 rule 1 and 2. In that, kindly look in para number 5 of the judgment. Power under 38 rule 5 of CPC is a drastic and extraordinary power. Such power should be exercised mechanically or merely for the asking. It should be used stringently and straightly in accordance with the rules. The procedure under rule 38 is not a convenient to an unsecured to death or debt into a secured debt. At any attempt of the plaintiff utilizing the provisions of 38 rule 105 or leverage up to the coverage or the defendants to settle the suit to claim of the should be discouraged in instance in waiting and appellant bold or doubtfully claims or realized or unsecured unsculptured plaintiffs by obtaining the orders of the attachment or before attachment or forcing the defendant to cut out of the court or settlement under the threat or attachment. Where these things were which I had not given, I am seeking to protect my action. If I succeed in the decree, how do I get out of? To repay my amount, I am seeking them.
In the lighter vein, this para 5 seems to be in my favor.
I'm straightforward. It's not for everybody. Everybody it is.
No.
It's the principle of
No, there is then the other judgment.
6 also is there.
Premraj Mundra versus Mohammed
Yes.
Munib Ghazi. From a clear of the court officer.
Yes.
What is this? What is the citation for this? This one.
Year 1951 Calcutta, my lord.
Year?
1951 Calcutta 156.
This principle has been followed till today.
Year 1959.
1951
51 Calcutta.
156.
Take that. We have. The agreed bidder. Is it recording? On it. You have to say dictation. It is not recording. It is typing. You have to on it. Ask him. Ask Siddiq. Oh. You ask him, it will happen. Is it typing? Agreed by the orders passed in I number 2 and 3, invoice number 5919 of 2016. The dated 26 July 2017, the plaintiff is before this court. The plaintiff appellant had filed a suit for, the appellant plaintiff had filed a suit for recovery of an amount of rupees 19,71,000.
19 crore.
19 crores 71 lakhs 80,605, along with future interest at 7.5% per annum from the date of filing of the suit till the date of payment, till the date of payment. It is a case of the plaintiff that in view of the close business relationship with defendant number 1, the plaintiff had paid him paid him the amounts by various checks and cash transactions between
8 to 13.
between 2008 to 2013. It is a case of the plaintiff that defendant had availed the loan from plaintiff for his business needs and he had utilized funds for purchasing various landed properties in the state of Karnataka and Tamil Nadu. That item number 16 to 20, the properties or the landed properties situated within the territorial jurisdiction of the court. And the said properties were purchased with the funds lent by the plaintiff, which is subject to the recovery in the suit. The plaintiff had come to know that the defendant is going to alienate the properties, and if the properties are alienated, even in case the suit is decreed, it would not be difficult. It would be difficult for the plaintiff to recover the money. As such, he has filed 2 applications. One is number 3 under order 38 rule 5, seeking attachment of the properties before judgment, and also another application that is IA number 2.
39 rule 1 and 2,
39 rule 1 and 2, restraining them from alienating the properties. The defendant had come before the court and filed his written statement. It is the case of the defendants are the defendants are 4 in number. The first defendant, according to the plaintiff, he had he had given the money. Second defendant is a wife of first defendant. Third defendant is a company for the purpose of which the defendant number 1 had taken loans according to the plaintiff, and later he has also become a director of the said company. And defendant number 4 is?
This is a company of the defendant number 1 and 2.
And the fourth defendant is a company belonging to the first defendant. The first defendant had filed his written statement. As per the written statement, the advances that are given by the plaintiff to defendant number 1 were duly transferred to the company G7 system by him. And thereafter, on instructions of the plaintiff, the same were treated as share application money in G7 systems. That is the third defendant company. Later, the same has been adjusted towards allotment of the share to the plaintiff and towards his investment in the company, resulting in the share application money being adjusted in the books of the company. According to the defendant, all is evident from the transactions that are placed before the court, wherein it shows that an amount of rupees 12 lakhs is shown as being treated as given as in the form of a shares.
12 crores.
12 crores to the to the plaintiff?
No, not for the plaintiff, to G7, to Sendil Rajan, not to the plaintiff. May I kindly look into the document itself?
On behalf of the plaintiff, it is sent to not to the company's account directly. And the company treats it as share application money
No, share of the capital,
whom?
of G7 Investments Private Limited.
Earlier they were,
Who has given that money? Who share it be to whom?
To the plaintiff.
He says not to the plaintiff, to the Senthil Kumar.
Not
He's saying it is not the
Plaintiff.
share of
no,
Senthil.
if I paid the amount to different number one, he had to pay the amount to me. If there is a transaction between the different number one and Sendil Kumar, I doesn't have any transaction with Sendil Kumar and his wife.
No.
No.
He has shown your name also.
Yes.
No, my name is shown based on the draft of my auditing letter he had shown to me, not on based of my share capital.
But that is not disputed anywhere.
Right,
He
it is
has
not
paid-
a draft, based on the draft it has been given, Mr. And form invoice of the ROC should be reflected. It is not reflected.
No, one thing you please make a specific statement. According to you, the 12 lakh amount, these shares that are allotted to the plaintiff
Yes.
or allotted to that Senthil Kumar,
No,
brother-in-law. of
allotted to
yours.
plaintiff.
No. There is no document before the court itself,
It
which
is
I
a-
had paid the amount to
it
the
is a-
different number one.
Please wait.
My kindly look.
Which document?
Document number 5 and 6.
You have 45, you have shown two documents. One is in name of Senthil Kumar, one other is in name of this plaintiff.
Only one name in respect of 67 lakhs which were shown to me, to the plaintiff. Not to the 12 crores to the plaintiff.
Yes,
At page 44, an email.
no, it is 54, come to 54.
Yes, I'll come. I'll take note.
54, it refers to 1 crore 40,000. For 1 crore 40,000. Number of shares file.
Yes, ma'am. One-
Yes,
10 lakh 4,000 number of shares, total number of shares.
not shares, amount,
Amount 1 crore for 1 crore 40,000.
that's it.
That is not neither plaintiff not. Neither of them are plaintiff. These
No,
not these
next.
persons.
No, something you have shown.
Yes, I'll take it. Next page is the plaintiff's name. Second
Ah.
one,
What is the name of the plaintiff?
Mr. Kandavel.
Kandavel.
Yes.
Kandabel Business, how much?
Not here it is shown as 67 lakh 60,000 amount. Your lordship may kindly see, this is the not face value of the shares. Your lordship may kindly come to the balance sheet itself. The balance
is
sheet
it?
shows,
Where is it?
the balance sheet shows the entire 12 crores money towards share application. Your lordship will, that is 65, it shows 31/3/2010 entry. Share application money pending allotment in 2010 and thereafter in 2011, it is allotted to the shares.
To whom?
To the same person, Mr. Kandavel.
No,
do
it's
you get?
transferred to G7
This is-
systems, not to me. But if I had given an amount to me, why should I have filed a suit?
But shares in G7 in the name of Mr. Kandavel, your lordship will see page 53 and page
We are referring
55,
to 12 crore
12
rupees.
crores. Yes,
And you are showing something about 67
but
lakhs.
this is, yes, this is all that is there. While allotment of shares, only the face value of the shares is shown here. Face value of the shares is shown here. In this is form number 2. But balance sheet will reflect,
No, you have to say that it is 12 crores. No, if for a moment you look at the very same the documents, Gunasekar so and so, for them there is a 2 crore 85 lakhs and in favor of some other persons.
not that is not, the lordship, which page, ma'am?
No, when you are showing advance of 12 crores and all,
Towards
at
shares,
page
yes.
number 46.
Yes.
Then it should also reflect in your shares.
But it is there. This is their document. I have not downloaded from the web. This document which is submitted to the ROC. The share application money of 12 crores is subsequently allotted to Mr. Kandavel, that is the plaintiff. And not the loan transaction. It is the investment transaction which the plaintiff is speaking about. Even his plaint, not paragraph 4, will not say give me interest. It will say give me profit at 7.5%.
According to the, what did you write?
Not para 4 of the plaint, the plaintiff on
According to
several
the defendant?
occasions.
The form of shares, according to him. The entire amount of 12 crores is given to the defendant, is paid to the plaintiff in the form of, is allotted in the form of shares. It is the case of the defendant that that the properties the plaintiff is referring referring that all the properties except the item number 15 is a self-acquired property of defendant number 2. And the immovable properties in item numbers 1 to 14, except item number 18 and item number 20 to the plaintiff were all acquired by the defendant number 3 company from its own source during the year. Now you are not a director.
I'm not.
He is a director.
Yes.
No, I am the director in my capacity, which I had paid the investment in the G7 systems as a 67 lakhs. Not in respect of the what I due from the 12 crores.
It's not that. Now he is not a director in the company.
No, he's not he had transferred the company to the name of to Sendil Rajan.
Hmm.
No, he has a transaction with him, he had transferred the company. What about my investment? My amount which I paid the 12 crores?
So that amount you can ask this person, the defendant and defendant, if at all any transaction with defendant number 2.
No,
But the company properties, why it should be attached?
The company properties for it, I am saying. The amount which I had paid, the amount transferred to the G7 systems, also different number 3 had been transferred the amount and the advice of the different number 1 itself.
So during the year 2000, item number 21 of the plaintiff were all acquired by the defendant number 3 company from its own source during the year 2008, 2009. The immovable properties in item number 16, 17 and 19 are properties that are acquired by defendant number 4 in the name of defendant number 2. And according to and even the defendant number 2 also filed a written statement. According to them, they do not owe any amount to the plaintiff. The trial court had dismissed the application filed by the plaintiff. While dismissing the application, the court has observed that to say that the respondents or the defendants are going to alienate the properties. Produced some of the sale agreements which came to be entered into by defendant number 2, who is the wife of defendant number 1, with third parties by manipulating the property numbers. The court has also observed that the plaintiff has also produced the sale deeds to show from the loan amount given by him to defendant number 1. He has purchased the landed properties in the name of defendant numbers 2 and 4, 2 to 4. The plaintiff has produced some sale agreements alleged to be entered into between defendant number 2 with third parties and some sale deeds. The court has observed that on the basis of the said documents, it is not possible to say at that stage that the defendant number 1 from the alleged loan amount by the plaintiff, he has purchased the landed properties shown in the application in the name of defendant number 2 to 4. The court has further observed that they have produced a memorandum of understanding entered in between defendant number 4 and 2 at document number 5 and memorandum of agreement entered in between defendant number 2 and 3 at document number 8. The document number 12, that is income tax returns produced by defendant number 3 for the year 2008-9, 2009 and 10 shows at this stage the company had sufficient resource to acquire the properties. So also the documents produced by the defendants number 2 to 4, that is document number 10, copy of the balance sheet of defendant number 4 for the year 2012, 2013, comma, copy of the balance sheet of defendant number 4 for the year 2008, 2009, comma, the copy of the bank statement of defendant number 2 and document number 6 shows the defendant number 3 and 4 companies as per the document number 5 and document number 8 memorandum of understanding in between defendant number 2 and defendant number 3 and 4. They have purchased landed properties as shown in the application in the name of defendant number 2. The court has observed that when that is the case, the contention of the plaintiff that the defendant number 2 has already entered into an agreement of sale with third parties in respect of the landed properties shown in the application cannot be accepted at this stage without holding a full-fledged trial. And all these aspects can only be decided after in the course of trial. Further, except item number 8 and 20, all the remaining landed properties are not standing in the name of defendant number 1. If the application is allowed and the properties are attached, much hardship would be caused to the defendants. Hence, the court has come to the conclusion that the plaintiff has not made out a prima facie case to grant the relief as sought in IA number 3. And even the material on record at this stage also does not disclose that balance of convenience lies in favor of the plaintiff. And as such, no hardship would be caused to the plaintiff if the relief as sought in IA number 3 is not granted. Accordingly, the court had dismissed both the IAs. Agreed thereby, the present appeal is filed. Learned counsel appearing for the plaintiff submits that the order, that is, the court had failed to consider the application as per the parameters and as per the purport of order 38-5. The court had decided this application as if the same is decided on an application under order 39 rule 1 and 3. He submits that when he has placed before the court that an amount of rupees 12 crores and all has been transferred, he has filed a suit for recovery of 12 crores and all, and also he had filed the documents, that is the agreement entered into by the defendant number 2 for selling the properties, scheduled properties. The court ought to have considered the scope of the petition and ought to have allowed the application. If all the properties are sold, it would be very difficult for the plaintiff to recover, even in case the suit is decreed, it would be difficult for the plaintiff to recover the money. He had relied on the judgment of the apex court in case of Ramantech Process Engineering Company and another versus Solanki Traders Extract 5 and 6. Relying on this judgment, the learned counsel submits that the findings that are given by the trial court shows that the court had not considered the application under order 38 rule 5, but rather had considered the application, the IA, the other IA that is filed by the plaintiff for seeking a relief, seeking injunction, not to alienate the properties. It is submitted that the order is liable to be set aside and the trial court shall be directed to consider the application afresh. Next paragraph.
One more submission. Or let them produce the guaranteed bank guarantee or any guarantee
He
security.
submits that to secure the loan that is given by the plaintiff, they should give there may be a direction to the defendants to give some amount or some property as secure bank guarantee. Next one. Then counsel appearing for the defendant, first defendant, you pay for all the defendants,
Yes, ma'am.
even the company.
Yes.
You are not a party director to the company.
Lord, I am the, myself and my wife, Lord, defend number 1 and 2 have.
Fourth third defendant.
D3 and D4 both.
No, you said you are no more a director.
Yes, Lord. Lord, I think, Lord, I did not make myself clear. D3 is G7 Systems Private Limited.
Yes.
The other company where the investment made is G7 Investments Private Limited. I have resigned from there. G7 Investments Private.
No,
And I have produced the memorandum of association of both the companies.
no, I was under the impression that you have.
I'm sorry, Lord, I did not make myself. Document number 2, Lord, kindly see in the written statement of defend number 1.
No, the shares which you are referring to are?
G7 Systems Private Limited, which is not a party before, my lords. But in the written statement of D1.
In his, in his contentions, it is submitted that the shares were allotted to the.
Plaintiff.
To the plaintiffs. What is the company?
G7 Systems Private Limited.
G7 Systems Private Limited. Instead of he has failed to complete the said company in the suit.
Or Mr.
No,
Yes.
In that company, you are no more a director.
No more. 15
He's a director in that company. He
Yes.
has nothing to do with this company.
Yes.
The next part. Having heard the learned counsels on either side, there is a material non-record. The suit is filed seeking recovery of an amount of rupees 12 lakhs, 12 crores and all. It is a case of the plaintiff that he had given loan, he had given loan to D1 and D1 had failed to repay the said amount and he has purchased some properties in the name of D3, D2 and D3 and he had shown as many as 1 to 10. Suit schedule, how many are the properties?
21 items are there.
20?
21 items.
21 properties are shown as a suit scheduled properties. In the suit for recovery of money, he has filed 2 applications. One is for attachment before judgment under Order 3825. And the other application is to seeking an injunction restraining them from alienating the properties. The stand of the defendant is that to the amount of 12 crores, shares are allotted to the plaintiff in a company that is G7
Systems Private Limited.
G7 Systems Private Limited. Those documents are placed before the court, before this court as well as the trial court. According to them, that company is a proper and necessary party to the suit. And if the said company is made party, all these issues would be decided by the court. When the court is deciding an application, under Order 38, Rule 5, before going into the same, there's appropriate look at Order 38, Rule 5, extract that.
And one more contention, Lord, that he would contend that he has given the loan to me, but he has made the D2 to D4 as parties, that is misjoined. And G7 Systems is not made a party, that is non-joint.
Whereas G7
well,
systems, I am not concerned about it.
Order
I had paid only to G7
Order
investments.
38, Rule 5. The whole purport of Order 38, Rule 5 is to safeguard the interest of the plaintiff in a given case. When once a decree is passed, the purport of Order 38, Rule 5 is to safeguard the interest of the plaintiff in case a decree is granted in his favor. And in every case of suit for recovery of money, just like that, an application under of an application that is filed under 38 Rule 5 cannot be ordered unless and until and the plaintiff makes out a case that there is a likelihood of selling the property for the defendant by defrauding the interest of the plaintiff. In this case, both the parties have taken two different stands. The defendant had, the plaintiff's case is that right from 2008 to 2013, he had transferred the money. According to the defendant, he has already been given shares in another company, which company is not made a party to the proceedings. And the suit is bad for misjoinder of, non-joinder of the necessary parties. And defendant number 2 and defendant number 3 are unconnected with the transactions between the plaintiff and defendant number 1. And as such, they cannot be pleaded as that is they've joined the parties who are not necessary parties to the suit. The properties that are 1 to 24, except property number 8 and
21.
Except property number 8 and 21. What are 8 and 21?
Item number 8 is a property which I have received under a partition decree. That is.
What is the nature of the property?
I'll just answer. Item number 8 not is a residential house.
21?
I stand corrected. It should be 20. It is a
8 and 20.
Not 19, not it should be. 19 is appears to be agricultural land.
8 and 19.
19.
8 and 19 are the properties belonging to the defendant number 1. The other properties or the other properties.
But 8 only defend number 1. 19 lot is defend number 2. Self-acquired property of defend number 2. 8 is the ancestral property received by defend number 1 in a partition decree.
8 is the only property which is in the name of defendant number 1. The other, the plaintiff had no connection with either with defendant number 2, 3 or 4. And he has not lent any money to the other defendants. And at this stage, it cannot be, the court cannot come to come to a conclusion that the said property is purchased by the defendant, first defendant, from the money that is lent by the plaintiff. It is submitted that now the suit is coming up for the
Trial. Plaintiff's chief examination is over. Set out
plaintiff.
for cross-examination of PW.
The case is coming up for the cross-examination of the plaintiff,
Witness.
of PW1. PW1. The court had rightly observed one aspect that the attachment, if an application under Order 38 to 5 is allowed, it would cause a hardship to defendants 2 to 5 with whom the plaintiff has
2 to
no
4.
2 to
4.
2 to 4 with whom plaintiff has no connection and plaintiff has not given the money to any of them. When it comes to defendant number 1, there is only one property that is standing in the name of the defendant as per the suit schedule property. As far as Order 38 Rule 5 is concerned, this court do not find though the court had not given any specific finding, but complete reading of the said order discloses that in the light of the stance taken by the parties and also the documents that are placed before the court are belonging to the defendant number 2, the court felt that the plaintiff could not make out a prima facie case for grant of an order for granting any relief under order 38 rule 5. But however, the property which stands in the name of the defendant number 1 is concerned, that is schedule item number 8 of the property. This court is of the view that instead of passing an order of attachment, the relief that is sought in IA number what is?
IA number 2 and
Injunction.
3.
IA number 3, that is an injunction restraining the defendant from alienating the property is concerned. This court is inclined to pass an order as far as the item number 8 of the suit scheduled property. Accordingly, the appeal is disposed of. Not appeal, sir. What is the other appeal? With the
2 IAs are there.
yes, against in the starting against 2 applications, 2 appeals are filed. So now 4 is against what?
What?
There are 2 appeals. are
IA number
filed.
39, IA 2 is against 39 rule 1 and 2.
No. Here 4 and 4.1 are there.
Yes.
4 is against which IA?
First appeal is against 39 rule 1 and 2.
Uh,
Second appeal is against 38.
38 rule 5. So 4.1 is dismissed. 4 is allowed, partly allowed. So and so with that attachment of that not to alienate as far as 8 is concerned.
But if
Yes.
not, your lordship may observe, if not already not solved, because this was in-
If it is not already alienated,
great.
Direct the trial court to dispose of the expedite the matter.
the trial court shall expeditiously dispose of the matter as this is a suit of
16.
2016 within a period of 6 months, but not later than 6 months. Yes, next.
Without influencing the findings given.
The court, all the findings, the observations that are made by this court are only for the purpose of deciding these are interlocutory applications. And the court shall, without influence, the court shall not construe any of these observations as an expression of the court and shall independently decide the suit uninfluenced by the observations. Yes.
Till
Not-
number 5.
Just to, sorry to not interrupt, just to clarify, your lordship is granting an order of temporary injunction insofar as item number 8 is correct.
Yes.
Not an order. of
Not to alienate, not attachment, not to alienate,
Great. If not already,
if not already alienated.
Till number 5. Abhinay Vaiti.
Registry has raised an objection that a separate application for delay and for setting aside the abatement is not filed. One application I filed, my lords, I've stated in my verifying affidavit, I would mention the provisions. But due to some inadvertence, I've not stated in my IA, I'll very well correct that.
You have corrected it.
I'll correct it now, sir.
You will correct or you have corrected?
I will correct it.
I'll give it to
You have
me.
to separate IAs, madam.
Hmm?
He has to file separate IAs for
What is that? Setting aside the abatement.
abatement and
All the provisions have,
There has to be section 5 is a different one.
yes, my
You have to
lords.
file one application under that, the other application for setting for restoration.
No, single application,
No, it is not that you, this is a suit, not a writ petition that in one.
Very well, if
petition,
my lords require, I'll.
The petitioner shall come, the appellant shall come up with appropriate application. The office objections or sustain, yes. And shall come up with an appropriate application within 1 week. Yes,
and direct provide us a copy. Appeal
copies
member.
are not given.
Annexures are not there.
For how many days you want to fight this 2016?
No, my lords.
The appellant shall serve the copy of the
Appeal memo and
the
all.
counsel for the.
Appeal memo is also not incomplete.
That's what I said, appeal memo, appeal memo on the relevant paper, the IA papers also on the counsel for the respondent. High Court GP, HCGP, yes.
Cell number 6 adjourned, cell number 7. Mubarak Begum is.
My lord, I'm appearing for the respondent in serial number 7. I've been
Yes.
served with a copy of the petition on 1st August. I require about 2 weeks' time to file my objections to this.
No objections are required. What objections in this?
My lord, the documents are not properly placed, my lord. In fact, the
What is
order.
this order?
My lord,
I have challenged the application filed by me under section 26, seeking visitation rights of the minor children.
What is order?
my lord, the
My lord,
order is at
kindly see
page.
annexure A, my lord, page.
1 minute, Mr. Council. Yes.
Yes, yes, ma'am.
The main observation at page number 35, my lord.
You are appearing for the father.
I am appearing for the father, my lord.
Oh.
Page 37 of the petition, my lord,
Please
the
read.
main. Para number 8, my lords.
Yes.
Upon having heard both sides, I have perused the material available on records, including the objections. Under the facts of the case, it is not in dispute that the petitioner and the respondent are staying separately, and the children are residing with the petitioner in Bangalore. Though the allegations made by the petitioner against the respondent requires consideration at this juncture, I am of the opinion that there are prima facie materials, and if the application is allowed and the visitation rights has been granted, that may affect the children's education as well as their behavior. And my lord, para number 9, my lord, under section 26 of the Hindu Marriage Act 1955, an interim order may be passed from time to time regarding the interim custody of the minor children. The records show that mediation has.
What is that
failed.
injunction order?
My lord, I'll come to that. I have filed another petition, my lord, which has been listed at serial number 26 in B group, my lord, today, my lords. 26, serial number 26, wherein I have challenged the order, the application filed by the wife, which has been allowed. She has filed an application under section 26, under order 39, rule 1 and 2 of
File
CPC.
MC for custody, GNWC.
My lord, this is an MC petition filed by the wife, my lord.
In that this application.
Yes, my lord.
Hmm.
So wife has filed the application restraining the father not to interfere with the peaceful life of the minor children and her parents. In fact,
What are the ages of children?
now, my lord, a male child is 11 years and the female daughter is 9 years, my lords.
From how
They have
long?
been removed from November 2019 from Pune, my lord. In fact, their schooling and they were born in Pune, my lord. They were along with their father. Due to the serious dispute arising between the wife and husband, they have been removed from
So
Pune.
what are the allegations that the wife is making? That for that the court has passed these kind of observations?
My lord, it's in the
there
previous
is no
paragraph.
material evidence has been produced. In fact, the allegations, my lord, when the wife has removed the children from Pune, from my custody, I have given complaint, my lord. There are, I have produced at annexure F, my lord. The complaints during that particular incident, my lord. Annexure D, my lord, page 43, my lord. These are the complaints I have approached the police at Pune and I have filed against her for the physical violence against the husband, against me. In fact, she was very abusive and physically she was torturing me, my lord. For that, I have lodged these complaints.
Why the father should not see the children?
My lord, may I just
He
answer?
was.
Yes.
My lord, the same impugned order, my lord, page 36, the previous paragraph my friend did not read. There is allegations of physical, sexual and mental abuse by the father. I agree, my lord, this is prima facie, but this prima facie examination has been done by the trial court, my lord, by the family court. The family court also says that this is all subject to, this all have to be tested in the trial. That is true, but there is enough sufficient prima facie evidence to restrain the father. Now, my lord, there are two IAs, my lord. There's an IA3 and an IA5. IA3 has been filed by me, my lord, asking for the court to restrain the father from visitation. This IA3 was decided in February 2023, my lord, 18 months ago, in my favor, giving the father no visitation rights at all because of prima facie evidence of physical, mental and sexual abuse, my lord. Now, on that, after that, my lord, the father has stayed completely silent till today. And now he files an IA-5, my lord. IA-5 is the impugned application here. And the order in this, my lord had rightly asked, what is this interim order that was passed? For the last 18 months, there is no challenge to the previous order, my lord. Today, the family court says that in the impugned order, you have not challenged the previous order, so I don't want to interfere with that earlier visitation order that I have passed. Now, two petitions have been filed, my lord, item 7 and item 26 in today's list. Item 7 is challenging IA-5. Item 26 is belatedly challenging the IA-3, my lord. Now, please see the impugned order in the file before your lordship, my lord. Page number 36.
Yes, I have seen.
Page number 36, my lord, the allegations made by the respondent, the last part of that, by the respondent in the affidavit are denied. He is in the habit of gaming for double money. First bought a bond due to surgery and doctor advice for being absent for 6 months from cohabitation. But respondent raped the petitioner.
All these allegations between the wife and the husband.
Yes.
Why
Yes,
should
my lord.
why he shouldn't see the children?
My lord, this is a reasoned order, my lord. That's why I said, let me file my objection.
That will be decided in the MC. That
That
this
will be
order,
decided in the
this
MC,
order
my lord. I don't
passed
want
by
to
the
get
court.
into. No, my only submission is this,
Tell
my lord.
one good reason why the father shouldn't see, except stating that what he did to the wife.
No, my lord, it is not just the wife, my lord. There is also materials that my friend has not placed, my lord. That's why I'm saying, let me place my objections on record. Let me show the same prima facie materials that were placed before the trial judge, my lord.
No
Because,
material is required. Let the mother and children come before the court.
My lord,
my lord, we
I
can
have
produce-
attended
I have
several
only
times,
one-
my lord.
I only have
Before
one
filing of this
request.
petition, I have been thrown out of the apartment, my lord. Please, my lord.
My lord, I only have one request, my lord, because this essentially this IA-5, this petition is arising out of an earlier visitation order passed in February 2023. The father has waited 18 months. There's no harm in waiting 2 more weeks, my lord. Let me file my objections. I'll produce the mother and the child also, if possible. Only once.
Not
once-
if possible. Court is directing. Court is not requesting you.
No, my lord.
Possible you should
Sorry.
come.
I'll correct my
Close
words.
this matter on 21st. On 21st, on that day, both the mother and the child shall be, 2 children,
Yes, my lord.
both the mother and the children shall be present before the court. And the father shall also be present.
Please.
Yes, at 5 o'clock in the chambers.
Um,
And whatever objections that the petitioner wants to file, respondent wants to file, shall be filed. At least 3 days before the date of hearing. And if any reply or objections to that, the rejoinder to that, if anything to be filed, has to be filed by the petitioner. Yes.
Serial number 26 is also same, my lord.
26 also, post along with 26. Serial number 26 to see the number. Yes, next.
Serial number
Great.
8.
My lords, I'm appearing for the respondent in this case, my lords. I'm very sorry, but I'm a counsel in Delhi and I've been appearing in the family court for the respondent in this case, my lords. My lords, they have filed an appeal, but they have not placed on record their own income affidavit before this court. What they have scrupulously done is they've only put on record.
Your petitioner is
Yes,
here, then
yes.
we'll hear.
But that's all I'm saying is if I can be given time to come before my lords personally.
We'll first know what it is, then we'll grant
Right.
time required. What
Yes,
is this writ petition?
Yes, madam. Yes.
My lords, this is an order. The husband's writ petition, father's writ petition. An application for maintenance was filed by the mother. And then there is an order to pay 40,000 rupees per month to the wife and 60,000 rupees per month towards educational expenses and 25,000 rupees as one-time litigation expenses. That is the order passed by the trial court. My lords, we had produced on the last occasion, it had come before your lordship in an earlier round in a different writ petition. Then this honorable court directed that it has to be heard at length because they had not filed an application. Then court had given permission to produce all the records and then this order has come to be passed, my lords. Now the question here is, my lords, may I just pass on this small synopsis so that we need not have to. Madam, our code.
Yes.
She had sought for 1,85,000 rupees per month. Second clause, your lordship may kindly come. And then along with 5 lakh rupees towards litigation expenses, my lords. My lords, the husband's, that is father's occupation is associate group manager And he is having a salary of 1,74,355, which your lordship will get it as annexure J and G11, which your lordship may kindly see for a minute, my lords. 1,74,000 rupees is what is the earning. And then
It's
we
a
had
maintenance issue.
Maintenance
Maybe
issue.
They want to come, we'll see.
Please, my lords.
When do
That's
you
the
want?
only thing is school,
But
school
that's-
fees, they have asked, we have already paid for the first, there are 2 terms which we have already
On the
paid.
next date of your,
So-
when,
Please, my lords, please.
when do you want?
My lords, 19th, may I come on 19th, my lords?
19th, there is,
19th is holiday, no?
Is it, my lords? Okay, then can I come on 16th, my lords?
You can come on 21st.
please, my lords.
My lords, I'm comfortable with 21st, my lords.
Yes.
21st.
So grateful, my lords.
At the request of Learned Counsel, the respondent, post on 21st.
Grateful.
9 parted matters. Sunil KN for petitioner Bapat Sampat.
Why it is
So-
adjourned on the last, counsel
Uh,
respondent shall indicate the amount of maintenance to counsel for fees. Where is he? Passover?
Yeah.
Passover? Passover?
Last time,
Some indicate, how much you have said, the maintenance amount?
maintenance,
I think you
one time,
remember
Lord, it
saying
will be,
something 40-50 lakhs.
that is very,
Possible.
that was not possible. Therefore, what I
What
What
you
I
say?
suggested to the other side is that let there be a monthly maintenance instead of giving in a one-time. And therefore, it can be sent back to the, now they have challenged the order of the interim maintenance, which was now before this court. Trial court has not gone into the material at all, and it was they were protecting the matter. Therefore, the interim order was passed for paying 10,000 rupees. Now that is the arrangement. Now it is stayed, and they are paying 5,000 rupees now. And
This arrangement go on and the matter can be decided by the court.
by the trial court.
So 5,000 will
Well, not
confirm
the
that.
5,000, 10,000.
No, interim order is 5,000.
Interim order before this honorable court is 5,000, but
But that he has to argue. Passover or you want some other date?
tomorrow.
Tomorrow. Yes.
Serial number 10. Waiting for the petition.
My lord, I bought 75,000 DD along with the post-dated check, my lord, for 51,450.
The other day he has given
35.
35,000.
Yeah,
Not 35, my lord, 31.
31,550,
31,550.
my lord.
Now what is
And
the amount?
earlier 50,000 I have deposited.
Huh?
Earlier 50,000 I have deposited. my lord.
Now what is the amount?
Now 75,000 DD I am giving along with the post-dated check for 51,450, my lord.
Cannot believe this check also, my lord. Check may bounce.
On 14th, I have given the date. my lord.
1,56,550. That would be 1,56,550.
Yes, my lord.
That is 31,550 the other day.
Yes, my lord.
50,000 as per the order of the court
Yes, my lord.
and 75,000.
DD. And a post-dated check also I gave
For how much?
for 51,450. That is 14th, my.
What
lord.
is the date?
14th, next week.
Then we will have it after that check.
Because we are not sure about this check.
Yes, my lord. we-
That's
we are
what I
wait- yeah,
said.
yes,
We'll
my
have it on the next day. Today, on the last occasion, DD was given for an amount of rupees 31,550. Today, another DD is given for an amount of rupees 75,000 and also a post-dated check for an amount of
51,450.
51,000?
450.
51,450. A post-dated check is given dated 14/8.
14/8.
14/8/2024. Post this matter on 14th, then post this matter on 21st.
Serial number 11. Admission. Nagaland Lane. The Raman. Respondent.
My lords, I'm for the respondent number 3 and 4 in this matter.
My lords, this matter has come up after almost a year, my lords. The date may be fixed. We are led by senior counsel. We'll argue. Date may be fixed, man.
Who moved the slip? Memo?
The appellant would have
We
moved.
have moved them.
When do you want?
It's 20th,
20th. The 23rd, my lords.
20, my lords, 20,
Not possible.
27th.
27.
27th.
At the request of land counsel, the respondent post this matter on 27th.
Serial number 12, Chandana,
For the
please.
appellant, seeking a password, senior has been engaged.
Passable.
Serial number 13,
I appear for the respondent, appear for the appellant. Maybe ASG is going to be arguing this matter. 30th is requested, I've just intimated the senior counsel. He had objection.
Post this matter on 30th. 30th is.
I hope it is a working day.
Friday
30th is Friday,
Will
huh?
not be possible. Then have it on September 2nd.
September 2nd, 1 minute, your lordship. Monday. Very well, madam.
September 2nd.
Yes,
At the request of land counsel.
keep you obliged.
serial number 14, Prakash Angbi, for appellant.
This is a matter pertaining to National Highway Authority of India. That's
This is what you are telling every day.
Please, minutes.
Where are the other matters? Where are the other matters?
The other matters, this our court has stayed, my lords. In this matters, there is no delay also. The lower
What is
court-
that order? Take that.
The lower court has ordered for 100% of the award, my lords, what he exceeding the jurisdiction.
It
they have-
is subject to the appellant depositing 75% of the award amount.
Please, madam.
Same order.
Yes.
Within 4 weeks from today. Is the,
Nuts.
Huh?
This, there is no delay, my lords. I may be permitted to deposit before the lower court 50%.
if it is delay, it is 75%. It is not about that. If there is delay, there will be separate cost for that. Because delay, the court has not said 75%. If you want same order, we'll give same order.
Same order.
If you otherwise, we have to hear and I may not grant this order also. The I number.
Yeah.
In I number 3 of 24. The notice to the respondents. In the meanwhile, the operation and execution of the impugned award passed by the arbitrator is stayed, subject to the appellant depositing 75% of the amount before this court within 4 weeks from today.
Not serial number 35 and
Notice it.
36 also same
35?
and 36 month. Same order. may-
Delay is not there.
No, my lords.
Then what about some objections are there?
My lords, I will. All have been, the PF amount has to be paid, my lords. I will pay during. the-
No, these are all batch matters.
Please.
35 and 36 also, same order.
There are
The office objections shall be complied with within 2 days, or else the appeal shall stand dismissed without further reference to the court. Yes.
2 weeks, my lord, to comply the.
Where is the delay?
They're connected 36.
Then 36 there is delay.
They have 538 days. in five
Notice may be ordered. Same order, my lord, because
Yes.
all pertaining to National Highway. Authority.
In IA number 3, IA number 1, notice.
Notice has already award to the
then-
claimant, my lords. It is no, already award.
Huh?
Notice is already, we have paid the process in
So
respect
what
of.
is the urgency? Every day you give slips, but you don't do what you're supposed to do.
That's, there is urgency that we have to deposit the amount, my lords, that is why.
In your 36 also, notice to the respondents, same order on 75% of the award amount. On all these orders, within 2 days, the office objections to be complied with, or else the appeal stands dismissed without further reference to the.
Next week maybe.
Why? No, 2 days. Yes, next. Stay.
Serial number 15. Serial number 15, Nataraj Bailar,
May I please you?
Yes.
for appellant.
But it's an defendant number 9, respondent number 9 in the FDP is before your lordships. On the
Defendant number?
9, my lord. The suit
Ah.
was filed for partition,
Ah.
OS 20/90/13. Suit is decreed.
Ah.
Against that, I have filed a RFA.
Ah.
In the RFA, my lord, an order has been passed in my favor. The staying of the drawing up of the final decree.
Hmm.
And section 54 is not complied. There is no partition of the property in question, my lord, by meets and bounds.
You are the member of the joint family.
I am a member, that is, but the present IA is filed in respect of survey number 18/9, my lord, where respondents herein observe themselves and coming to the property, my lord, and have put up construction and completing a house, against which, my lord, I filed an IA before the FDP court, seeking for an injunction. Because, my lord, the decree has been stayed by this honorable court.
Ah.
The drawing up of the final decree has been stayed.
State.
Despite this, my lord, one of the respondents herein, they come into and barge into the property, my lord, which I am in possession, and have put up construction of the house, for which I file an IA, my lord, seeking injunction. The trial FDP court, my lord, rejects it, against which I am before my lords, my lord.
No, when your appeal itself is pending before this court, why you did not make an application before this court?
Lord, either I have to file before the
No,
RFA, my lord, I have to file an RFA.
File before
I
RFA
have
court
filed
only.
that application. That application has been filed there, my lord. That application has been dismissed on the stay, saying that, my lord, only the final decree proceedings would be stayed. Drawing up of the
So
final.
that means
Please.
court is not inclined to grant injunction.
No, my lord, in that event, my lord, even without complying with section 54, without being the parties being allotted with.
Now let us make it like this.
Please.
Now you filed an injunction petition when a pending RA.
Pending
court-
FDP, my lord, pending FDP.
No, before that,
Before that, in the RFA, I filed.
you have filed.
Yes,
Court
my
has
lord.
dismissed it.
Court has dismissed it on the grounds.
Because we will not grant you any other relief except only will grant you stay of passing of the
Final decree.
final decree.
Yes.
Then very same application.
No, that it is not, it is a different application. Thereafterwards, I filed an injunction
No,
application.
relief is same.
Relief is the same, my lord, because at that point of time, my lord, the construction was about to be started, my lord. That is why I made a application before the RFA division bench, my lord. Division bench said, I will stay the drawing up of the final decree.
Because the appeal is pending, anything that is happening and when the parties are before the court, you have to appropriate
That
means only to
my
the.
lord, I will, that liberty may be granted, my lord. I'll move the
What
RFA.
liberty?
When this appeal may be, I'll withdraw this appeal, my lord. I'll file an application before.
The petitioner, when the matter came up for hearing, land counsel appearing for the appellant, seeks permission of the court to withdraw this appeal and to avail the appropriate remedies available to him. Accordingly, dismissed as withdrawn.
Please.
Yes.
Number 16. Serial number 16, Chokka Reddy.
Appearing for the respondent now. Please, your words. Can you pass for this? 230 senior is arguing in some other
What?
court. 230.
Also,
Serial
Yes.
number 17. 17, Hanuman Reddy.
Appearing for the appellants. Appellants are the NHAI. Here we have challenged the order passed by the learned district judge in respect of the AP number 213/2023. The learned district judge had confirmed the arbitral award passed by the learned arbitrator, wherein the enhancement has been done without justification. If your lordship may kindly peruse the annexure B, I have annexed to my memorandum of appeal. Page 52, my lord, the order has been passed by the learned arbitrator, subject to no explanation or any inquiry held in that regard, my lord.
page
The
number-
land, page number 52, my lord. The land of the respondents were acquired, subject to which the respondent had filed an application under 3G5 for enhancement of compensation. Subsequently, the same has been enhanced to that effect which has been mentioned there under in the table. However, there has been no specific explanation or any.
Yes, before going into all that, please come to the order so that the court will understand.
Please, my lord,
Then you
please,
can make
please.
your submissions.
Annexure A, my lord.
Yes.
The The operative part of the order is at page 40, my lord.
What is wrong with this order?
Please, Your Lordship, our contention in respect while challenging the arbitral award was it is against the fundamental policy and subsequently there is a patent illegality on the face of the award. If Your Lordship may kindly page 18 of my memorandum of appeal, I have let down the judgment rendered by the Honorable Apex Court, wherein
No,
if the
I've seen that, you say
Please,
that
please.
it is because unless and until an arbitral award cannot be questioned, you have taken two grounds, public policy. and-
Please.
What is that public policy? What is the violation?
Please, my lord, if Your Lordship may see para 32 of my memorandum of appeal,
Para 32.
Para 32, page 18, my lord. The Honorable Supreme, if I may read. The Honorable Supreme Court in the case of Associate Builders versus DDA reported in so and so has held in para 34 as under. It is with this very important caveat that the two fundamental principles which form part of the fundamental policy of Indian law, that the arbitrator must have judicial approach and that he must not have acted perversely, are to be understood. Subsequently, in para 42.2, it was held that if an arbitrator gives no reason for an award and contravenes section 31(3) of the 1996 Act, that would certainly amount to patent illegality on the face of the award.
Then where is the award of the arbitrator?
In this case, my lord, that is here on in page 52, my lord. If I may.
Let's see what was not considered by the arbitrator.
Please, my lord. My lord, by exercising powers under section 3G 5 to 7 of the National
The
Highways Act.
amount that was granted is initially,
Please, it was, my lord, there were two acquisition proceedings, my lord, and subsequently two awards were.
no, as far as this is concerned,
Please, ma'am.
initially an amount of rupees
69,244%. And your lordship, there were two awards passed by the Special Land Acquisition Officer in respect of the property pertaining to the respondent, wherein there were two acquisition proceedings.
So
Initially,
rupees 2,19,509.
please, my lord.
Percent was fixed by the LAO.
Please, my lord.
Hmm.
Then subsequently it was enhanced to 2,72,189. Now there were no reasonings provided as to whether for what reasons the said enhancement has been done, because as the 3G7 of the National Highways Act speaks about, the determination of the compensation is subject to the market value of the land on the date of the 3N notification, which was duly considered.
Let's see now, please come to the award.
Please.
And how the arbitrator has not considered this.
Please.
Page number?
Page number 45, my lord. That is annexure B. That is where from which the arbitral watch.
Let's see. Please come to page 51,
Please, my lord.
point number 3, please read.
The contention of point number 3, my lord.
Yes.
The contention of the applicant that he is eligible to get rupees 1 crore. The applicant has not produced any proof to substantiate his claim. As per section 3G7 of the NH Act 1956, the second respondent has to determine the compensation at the rate on the date of publication of section 3A1 of the notification and not any other date. The second respondent fixed the compensation in accordance with law. Hence, the claim of the applicant for the compensation of rupees 1 crore cannot be considered and the same is liable to be rejected. Please, my lord.
Now, basing on what he said, so all this. Basing on how this is enhanced.
Beg my pardon, that is, my lord, there has been no substantial evidence provided by the respondent before the learned arbitrator for any enhancement. Your lordship, the point number 1, which is given in affirmative by the learned arbitrator, that there has been no dispute that the land acquisition officer has determined the compensation in accordance with the provisions of the National Highway Act.
No, what is the, I think no reason is given why it is
Please, my lord.
enhanced compensation as per this order.
Against which
For
we
the
had,
detailed reason explained in point number 2 above. What did he explain in point number 2?
in point number 2, the only thing which the learned arbitrator
Only stated is ABCD.
points out is that
So
subsequently.
that is some kind of a discussion. Then coming to these particular lands, what is the market value? What is the book value of it? What is the
Please, my lord.
land? Nothing has been discussed.
Please, my lord.
Please come.
That is again. Your lordship, we have filed an interim application along with the memorandum of appeal to stay the order passed by the learned district judge and consequently the arbitral. So
No, that amount is paid. The original amount.
original amount given by the land acquisition, awarded by the land acquisition officer has been already been paid. This further only in respect of the enhancement award.
The present appeal is filed by the National Highways Authority, agreed with the order passed by the civil court in AP number 213 of 2023 dated 18th April 2024. The National Highways Authority has acquired the land belonging to the respondents, and the land acquisition officer has fixed the compensation. Aggrieved thereby, the respondents herein had had filed AP 213 of 2023 dated 18th April 2024. The court below, the trial court, the appellate court had dismissed the appeal filed by the National Highways Authority. Aggrieved thereby, the present appeal is filed. Land council submits that when the land acquisition officer has fixed the compensation as per the provisions of the act, and when the arbitrator has enhanced the same, no reasons were given, and the court also, when the award was questioned before the court, the court also failed to consider the same. They submitted that for enhancement of the compensation, the court has to, the arbitrator has to give the reason. Without any reason, the same is done. This court has perused the order passed by the arbitrator as well as the order passed by the court. It appears that the order of the arbitrator suffers from a proper reasoning. Hence, there shall be stay of all further proceedings. Pursuant to the order dated so and so. Date of the arbitrator dated so and so. Notice to the respondents. Notice, the registry is directed to issue emergent notice to the respondents. Yes.
Your lordship, humble submission. The present order dated by the learned district judge and the arbitral award may be stayed for.
That's what state.
Please, please. Grateful, my lord. Deeply.
My lord, serial number 18, we need to file statement of objections to the appeal.
Now.
Madam.
Pass over.
Passover matter, serial number 12.
Learned senior is appearing through VC.
Yeah. Which is the passed over?
Serial number 12.
Yes.
Tanapi, Abhinav Ramanan.
Where is the senior?
He's appearing through VC, my lords. He's on his legs in another matter in Dharwad bench. So he said he'll appear through VC. I've just informed the learned senior.
Yes. Call him. Yes, next.
Serial number 16. Passover serial number 16. Sakareki.
Yes.
Please, Your Lordship. Now, the MF first one, MFA number 27998 is connected with MFA number 2802 of 24 month. Arise out of the same suit. OS number 84.
2A.
No,
MFA
other two appeals arises out of suit in OS number 80 of
No. You said MFA 2798 and
2802.
2802 arising out of the same suit.
Same suit.
What is the suit number?
OS number 84 of 24.
The remaining two are with regard, they are also of the same suit.
No.
That is,
Another,
I mean,
another suit.
Another suit. 2800. Yes. That is arising out of which suit?
Second one, first one is 84.
Yes.
Second one is 80 of 24.
80.
Please. First one, 2798. Now, the plaintiff filed a suit. It is plaintiff's appeal. Man. Plaintiff filed a suit for declaration and permanent injunction. Stating that, my lord, the land was originally granted. His predecessor in title, my lord, one Pilla Doddappa on 14/10/1963. And my lord, there were Darkast records, and we have produced all those in the, even before the trial court as well as here. There were, my lord, Darkast register, OD sketch, grant certificate. Grant certificates were produced. After PODI, my lord, originally it was survey number 31. 31. After, my lord, PODI, it was bifurcated as survey number 77, measuring 2 acre 12 guntas.
Yes.
And survey number 83, measuring 29 guntas.
Yes.
29 guntas. My lord, it is the case of the plaintiff that the after the grant, my lord, his LRs have been in continuous possession and enjoyment. When this was the position, my lord, respondent and 12 and 13.
Yes.
My lord, created or a sale deed create, it is the contention of the plaintiff, created sale deed dated 28/11/2005 in favor of respondent number 1. They are claiming rights, respondent number 12, my lord, one MR Narayan Swami and MR Srinivas Murthy. They are claiming right, my lord, on the basis of unregistered gift deed.
By whom?
By their father. 4/3/1994.
So 12 and 13 are claiming ownership by way of an unregistered gift
deed. Your lordships are well aware, gift deed is defined under section 122 of Transfer of Property Act. And gift deed has to be compulsorily registered, my lord, it has to
effect of the entire extent.
Yes, my lord, oh, it's suit schedule.
No, the sale deeds or the gift deed and the subsequent sale deed in favor of 12 and 13 is in respect to the entire suit schedule.
Suit schedule, Prabhu.
Yes.
So, my lord, gift deed is not registered. Under section 17(1)(a) of the Registration Act, it has to be compulsorily registered. So, after sale of property in favor of respondent number, based on the gift deed, my lord, unregistered gift deed, mutation entry was effected.
In 2005.
No, 4394, unregistered
90
gift,
fund is the gift deed is 94.
94.
Hmm.
Based on that, my lord, mutation entries were effected. And
Continued from that.
is sold in favor of respondent number 1. My lord. Respondent number 1 to 14, who are all his family members, there were some family partition in between them. And they sold, my lord, in favor of respondent number 15 on 6/6/2022.
Who sold?
My lord, respondent number 1 to 4. 1 to 14.
1 to 14 in favor of?
In favor of, my lord, defendant number 15 or respondent number 15. Respondent number 14 was a confirming party who has confirmed the, my lord, execution of the sale deed. Having come to know of all these proceedings, we have filed the present suit for declaration and permanent injunction based on the, my lord, original grant records and, my lord, PODI records and the statement made before the authorities. All those documents we have produced. In our appeal memo, my lord, we have stated in detail. Those are all the what are all the documents we are relying upon.
Then you sought an injunction.
Sought for an injunction.
Which is dismissed.
No, but notice was issued by the learned trial judge.
Now let's please come to the order.
Against that, my lord, we filed writ petition before this honorable court for non-granting of injunction. An order of status quo was granted by this honorable court. Under 2 IAs were filed. IA number 1 is, my lord, for not to alienate. IA number 1 of 24. IA number 1 was, my lord, for not to alienate. IA number 3 is not to change the nature of the land. It is still agriculture land.
So what the plaintiff is doing from 1994?
But they continued in possession. All these transactions, we were not aware of it. Having come to know, but when the mutation entry we came to know, we filed objections before the Tahsildar.
When is that?
No,
So
it
what
was
the fact remains is right from 1994 till now, the mutation is in favor of.
up to 94, my lord, the name of the Pilla Doddappa was continued.
What is the relation between the plaintiff and the defendant?
No relationship. They are claiming MB Ramappa, my lord, my lord, he is said to have executed unregistered gift deed in favor of respondents 12 and 13 on 4/3/94. So the original title itself is, my lord, through which they are claiming, my lord, is defective.
Yes.
Our case is based on grant. Therefore, we sought for declaration. And
what are the documents that are filed by the plaintiff to show that he has been in possession of the property right till the date of filing of the suit?
But up to 92, 93, our names were entered. 94. Thereafter, my lord, based on that documents, their names came to be entered.
Apart from that, what is the nature of the land?
Agriculture land. It is vacant land. Now they want, it is not yet converted. Now they want to change the nature of the land. Therefore, we have sought for declaration and permanent injunction. So when status quo order was granted by this honorable court, and if I am correct, my lord, other side also considered that till the disposal of the IA, the interim order may be continued. So status quo order was continued. However, my lord, while disposing of the IA number 1 and 3, the learned trial judge holds that, my lord, you have kept silent for all these years. And the defendants have to prove their case. plaintiffs have to prove their case and defendants have to prove their case. Therefore, I refuse to grant an order of injunction. And tribal case is there. And my lord, the claim is based on a grant in favor of my predecessor in title. My lord, mere, your lordships are well aware, mere revenue entries, my lord, would not confer any title. So moreover, my lord, order of status quo was, my lord, in force. My lord, may I pass on the order of, my lord, status quo granted by this honorable court. Yeah. The 84.
Is here.
May I pass on?
Is this the order? Justice Krishna Kumar.
Please, ma'am. This is WP number 4158 of 2024.
Yes.
Clause number 5, madam.
Please come to the order of.
Please. Reasonings, page 19, my lord, in MFA number 2798 of 2024.
Yes.
Please. The plaintiffs have filed the suit. May I just read, madam?
Yes.
The plaintiffs have filed the suit for declaration to declare the sale deeds dated 28/11/2005 executed by defendant number 12 and 13 in favor of defendant number 1 and sale deed dated 6/6/2.
Yes.
Your lordship are on next page.
No, you can read.
I am a little bit slow.
No, you can.
Executed in favor of defendant number 5 are not binding on the plaintiffs. Permanent injunction is also sought against defendant number 15 from alienating and from interfering with the suit property. The case of the plaintiffs is that Dodda Pillappa was granted 3 acres by Darkast on 1/10/1963 of land of Lingadira Gollahalli village. Grant certificate was issued. Mutation was effected in his name. The land was podied.
Yes, you can continue to read. I am looking at it.
Please. The possession of the grantee is shown in Podi. The father of the plaintiffs was a grantee in survey number 31 of the said village measuring 30 acres. After Podi, now the new survey number 77 measuring 2 acres, 12 guntas of Dyavarahalli village and new survey number 83 measuring 29 guntas of Lingadirahalli village. The plaintiffs are undivided joint family members. Defendant number 13 has no right over survey number 83. He created, your lordships are on the next page, ma'am.
No, please read.
No,
because, to read and to read out,
then your lords may go through, my lord.
Yes.
Police complaint. Page 22, my lord, below 4 lines.
Yes.
They are relying upon, my lord, gift deed dated 4/3/94.
Yes. Yes, yes.
My lord, page 23,
Yes.
the learned judge, my lord, 10 lines from the bottom, the plaintiffs have to prove the plaint averments as pleaded.
Yes.
The defendants have also to prove the contentions.
Yes.
So we have, my lord, when we came to know about the, my lord, mutation entry, we have, my lord, filed objections before the Tahsildar.
Yes.
He rejected our contention. Now it is challenged before the assistant commissioner, matter is pending. When there was interference to our possession, my lord, we filed, my lord, police complaint, and there was an attack on us. Then we filed, my lord, we have produced
Also in 24. That is also
in 24.
Hmm.
So
Yes.
all those documents to show that, my lord, there was interference, we have produced.
Yes.
And photos also we have produced. My lord, kindly see, my lord, page 142, my lord.
Yes.
Original photograph, what? Xerox copy.
Yes, 142.
It's a vacant land.
Yes.
143, 144, 145.
Yes.
MLC register is, my lord, at page 176, my lord.
Yes. Yes.
So their contention is, my lord, kindly go to, my lord, page 159 in the written statement, para 9.
Yes.
The defend number, para 5-1.
Yes.
The defend number 15 submits that MB Ramappa had gifted the food schedule properties and other properties belong to him to his children.
You're reading para 9?
Para 5,
Para.
page 159.
Yes. Yes.
The defend number 15 submits Sri MB Ramappa had gifted the food schedule properties and other properties belongs to him, his children, under gift deed dated 4/3/1994, and in this said gift deed, food schedule properties was gifted to defend number 12 and 13. In further paragraphs, they say about all those sale deeds.
Yes.
Partition in the family of defendants.
Yes.
Gift deed we have produced, my lord. It is Kannada, my lord. We will produce the translation also, my lord, if necessary.
According to them, it is from the year 1989, 88 to 89. Even from that time also, the name of this MB Ramappa finds place. Para number 4, please look at para number 4.
Enjoyment of all the revenue stood in the name of, in respect of, in the year 1988-89, Podi and Dirasti has been conducted on the basis of the possession of the properties. My lord, we have produced the record of rights. My lord, kindly translation, it is in English also. Page number, my lord, 77, my lord.
77.
77.
Yes.
70.
Looked into it, the translation in English is not correct. Maybe my learned friend may have to. That's at page 74.
Yes.
What is the?
After 91-92, my lord, their names.
Not 91-92. I am only referring to that 88, 89, 89.
90-91 ಇಲ್ಲಿ ಇದೆ.
Mistake ಏನಿದೆ ಅಂದ್ರೆ the name of the village at the top at page 74 is Lingadhiranahalli. That is not found in the translation given by my learned friend.
Sorry, my lord, there is some mistake in translation.
So where is the original? I mean, in Kannada.
Kannada.
It's in Kannada.
Where is
village name is Lingadhiranahalli. There is no dispute.
No, let's not go to the translation. Where are the Kannada documents?
Kannada, my lord, idyake ಹೊಡೆದಾಕಿದ್ರು.
Page number
74, man.
74. Please come to that document. What it says.
Pilla
What is the
Doddappa
name?
for 88, 89.
Just a minute. At the top, it says Taluk,
Devanahalli.
Devanahalli.
Hmm.
Then Hobli, that is the subdivision, Kundana.
Hmm.
Then Grama, that is village,
Hmm.
Lingadhiranahalli.
Hmm.
You know, we also contend that it is situated in Lingadevarahalli.
No, no, no. They are-
After Podi,
Records not mutated in his name.
Podi records not mutated in his name.
Hmm.
Originally, it was
Present properties claimed by them is Devarahalli village.
Devarahalli.
Devarahalli village. Devarahalli village.
And these pertain to which village you said?
This
Ling-
pertains to
Lingadevarahalli.
Linga Devarahalli.
And we have produced the Podi records also, man.
Please, for a minute, come to the plaint schedule. And where is the plaint?
Plaint, please. Plaint, my lord, page 34, my lord.
Yes. $34.
Please. So plaintiff number 1 is, my lord, a family member.
You're talking about Kundana Hobli.
Schedule.
Devarahalli village.
Kundana Hobli, Dyavarahalli village. After Podi.
Hmm.
Another is item number 2 is Lingadhira Gollahalli.
No, the particular document you're referring to of this village,
Lingadevarahalli.
Linga Devarahalli,
Survey number
at page number 62.
62. So grant certificate also we have produced, my lord.
No, I'm looking at page 59. What is this at page 59?
59, my lord, name of Narayana Murthy. Their names came to be.
This is pertaining to Linga Devarahalli.
Dyavarahalli.
Devarahalli. So, Devarahalli means that is item number 1.
Item number 2.
No, item number 2.
Item number 1. Item number 1.
Item number 1. So please come to that. What is this? What is this document called?
This is record of rights.
Record of rights.
Names of, my lord, page 59, name of respondent number 12, Kumar Narayan Murthy. His name is found, my lord.
Respondent's name.
Because, my lord, based on the unregistered gift deed, their names came to be entered.
Then where are your names? In which document?
Grant certificate.
Let's see that grant certificate,
Please.
page number.
That is at page 48, my lord. Typed copy we have produced.
48. This was of which year?
63. Grant
This-
certificate.
And this refers to Linga Devarahalli.
Yes, my lord. Dodda Pillaya. Name of the.
No, it is Linga Devarahalli.
Please.
No, you have mentioned about two properties.
Survey number is mentioned, my lord, page 52.
That's what, I'm there at 52. 52.
52. Lingadevarahalli. Survey number 31, before Podi. Thereafter, my lord, Podi was conducted. Application was.
No, survey number is changed or the village itself will change?
Village is also changed.
Later, after the Podi, what are no, as per your schedule, it is 2 villages.
Yes.
And the documents should also be referring to the 2 villages.
OD revision settlement records, we have produced, man.
Hmm.
It is,
So please show as per that, your, whatever the grant that is given to you is in respect of this particular suit schedule.
survey number 31 totally measures, my lord, 3 acres.
Hmm. So there must have been some record after the resurvey.
Resurvey page 55, OD records.
What it says?
Survey number 1, my lord, it was originally 3 acres, Podi ante 2 acre 11 guntas. 7, mele, Pasa survey number 77. So up to, my lord, before execution of the gift deed, my lord, our names were there. And my lord,
Gift deed
and
was, no. Gift deed was executed in the year
unregistered 4394.
4394.
There are some gaps, for some years it may not be there.
No, that's why. Before 94, please show the entry of your name in the revenue records. Before 94.
We have produced in respect of 1 survey number.
But the property, plain schedule.
Survey number, page 74, survey number 77.
But there are 2 properties,
Innondu.
2 survey numbers.
It is not produced here, 77 only it is produced.
Hmm.
So, my lord, all these title documents and sale deeds and all this, it's a matter, my lord, which has to be tried, my lord, in a suit. As on today, it is a agricultural vacant land. So, my lord, if third party rights are created, my rights will be affected.
Yes.
So, status quo order was granted by this honorable court. It was in force during the pendency of the suit when application for injunction was under consideration.
Complaint is after the status quo order. The complaint, police complaint is after the status quo order. No, you're referring to a fight between the parties and a police complaint. That is after the status quo order.
But there was after the status.
That is what is the effect of
When
status
they have
quo.
interfered, my lord.
No, generally,
My lord,
status quo
even
orders are neither here
my lord,
nor there.
My lord, even my lord, learned judge also, my lord, holds that they have also to prove their contention. We also have to prove our contention. So when a triable issue is there, my lord, the person, my lord, protection should have been extended to the, my lord, parties who have approached the court. Yes. So that, my lord, third party rights may not be created in the meanwhile. Then, my lord, everything cannot be reversed.
Yes.
So my submission is that either, my lord, a protection against alienation may be granted, or a position as which is existing as on today may be granted. And we are ready for, my lord, disposal of the suit within 6 months, my lord, suit can be disposed.
But court has to be ready. It's a suit of 2024.
My lord, we will, my lord, as a special case, my lord, if parties cooperate, my lord, it can be disposed of.
Yes.
So,
yes.
So in other, my lord, it's a different.
For the other one?
OS number 80 of, it's a different grantee. Nagappa was the original grant.
It's a different case altogether.
Same title.
Same title, grant certificate.
Same, very same.
Everything
Similar,
is same.
similar grant certificate.
Same gift deed.
Same defendant. Same defendants. So I pray that, my lord, appropriate protection may kindly be.
I would start with the records stand in the name of M.V. Ramappa. At no point of time there is any record with regard to survey number 77 of Devarahalli village. There is no record in favor of the plaintiff at any point of time. Much is sought to be made about the unregistered gift deed. It's actually not a gift deed, though they have title is given as gift deed. On the other hand, the reading of that deed I would rather furnish a translation and they say, but the reading your lordship may kindly say without any apprehension of contradiction. Father effects a partition of his property in favor of his 4 sons. He has titled it as Danapatra or gift deed. It's not actually a gift deed. And immediately after about 3 years or so, he passed away also. The property which he effected partition. He says, these are my property. This portion shall go to my first son. This portion shall go to my second son, third son, fourth son, like that he gives the property. In that, defendant 12 and 13 have got these 2 survey numbers. That is in 1994. Even at that stage, at no point of time, there is any reference to the plaintiffs herein or anybody of. On that, mutation has been made. That is not challenged till 2020. Yeah, even now that is not challenged. Only after the Munishamappa purchased it, and from Munishamappa, the defendant number 15. 13 and 14, Allah.
They have sold it to 15.
Defendant number 13. Defendant number 15.
Yes.
Till then, none of these things had come for almost, it's about more than 35 years. Trial court has noticed these things and therefore said at this stage, no case for granting an order of injunction. There were 2 applications filed. One, not to interfere. First, not to alienate. Along with the suit, and the next application was not to interfere with the possession. My respectful submission is, court below, in effect, comparatively looks into the case made out by the plaintiff and points out it's almost about 35 years you have not raised a little finger. At this stage, it's not something that could be done unless, as your lordships would notice, unless the order is on some ground is characterized as something which is capricious or totally arbitrary in some way. Normally, I'm not saying that court has no power. What I'm saying is, normally, there will not be an interference with the order. The status quo order, which is sought to be made as the main basis, I would respectfully submit, they had taken an interim order of stay of further proceedings. The court said, let the IA be considered. We agreed that let IA be considered. Till then, both the parties don't do anything, let the court consider. Now the court has considered and has prima facie pointed out there is no reason to pass any order. It's actually the gift deed which is titled as gift deed. Your lordship may kindly see. I should have got it translated. I'm sorry, but it specifically says.
Where is it? Page number?
It starts at page 154. First, it says Danapatra, and it recites the names of his 4 sons. Second para, I so and so, aged about 83 years. Second para says, I'm giving it Danapatra. Then the third para refers to the properties held by that family or MB Ramappa, father. Fourth para says, all of you, that is 4 persons, are my children. You have been looking after me all these days. Therefore, I want to give these properties by way of gift today itself. That is fourth para, page 155.
They are all his children or any.
All the four are children. That's why I said it's actually a partition deed effected by him during his lifetime itself.
Now, how it concludes? Last para
It concludes,
at 156.
please, madam, at 156.
Last paragraph.
I will only, I will just read that and point out. 156, second para. He says, all these properties are not in any way encumbered. I have not given it to anybody. There are no rights of any third party. Third para says, these properties are already in your possession. Therefore, again, handing over possession will not arise. But anyway, I'm handing over all the documents pertaining to this property. Then he says, there are no court cases, etc. If anything of this sort arises, I myself will look after it. He was already 83 years old. Then the last paragraph says, I have executed this deed without any coercion or influence. I'm doing it voluntarily by myself. Of course, he refers to it as Danapatra. There is no this thing. But from paragraph number 155, two paragraphs pertain to son M.R. Govindaraj. Third paragraph pertains to Srinivas Murthy, that is survey number 77, which is the one here, a portion of survey number 77. Last paragraph pertains to
yes, yes.
154, last paragraph is in respect of two sons, M.R. Venkatesh Murthy and Srinivas Murthy.
Yes.
155, second para pertains to Govindaraj. Third para pertains to Srinivas Murthy.
Yes.
Each one, he says, even in survey number 77, a portion, 81, a portion, like that, in effect, a partition is effected during his lifetime and he has given it for what were the, this thing. But anyway, after this, an entry has been made. That entry is not challenged. Prior to that, it stood in the name of Ramaswamy. B.M. Ramappa. It stood in the name of father. Then after that, it stood in the name of their children in respect of even other properties. 77 was not the only property.
Yes. Yes.
Then ultimately, transaction started in 2005. The parties sold it to Munshamappa. Then thereafter, there are another two transactions.
Yes.
Please.
By way of reply to me.
Yes.
On page 45.
Yes. Yes.
Lord, survey number 70, last two lines. Survey number 83 measuring 29 guntas of Linga Dira Golhalli village. 77 of Dyavarhalli village measuring 2 acre 11 guntas was allotted to Pilla Toddaya. Then, my lord, the gift deed, my lord, page 154, it is titled as, or it is described as a Danapatra.
That I see.
And Atma Santoshadinda, out of love and affection. And in their written statement, they say gift deed. Now they cannot say that. Therefore, my lord, some protection may kindly be granted.
The present appeal is filed by the plaintiff, agreed with the orders passed in I number. Not happening. It's on. Just press it. The
Page 15, it's on IA number 3, not to change the nature of the schedule.
It is connected with 2802 that I have told.
Oh, they should on or what? It's on. Agreed with the orders passed in I number.
Whether brief synopsis.
Take that. I number 3.
Oregon copy code.
Invoice number. It's only one IA.
Two, my lord,
The other is
2798 is connected with 2802.
orders passed in.
One IA number 1.
IA number 3 is
3 in OS number 84 of 24.
the present appeal is filed by the plaintiff. Agreed with the orders passed in IA number 3, IA number 3 and IA number 4, invoice number 4 or 5.
IA number 1 and 3.
1 and 3.
Agreed with the orders passed in IA number 1 and 3 in
Date.
OS number 84 of 2024 dated 15th April 2024. The against the dismissal of both the IAs, 2 appeals are filed before this court. One is MFA 2798 and the other appeal is MFA 2802. Take that, no, that 2802. The suit is filed seeking the relief of declaration,
And permanent
that the
injunction.
petition, that the plaintiff is the absolute owner of the sued properties, to declare that the sale deed dated 28/11/2005, comma, 20, in document number 4313 and sale deed dated 28/11/2005, in document number 4281 and sale deed dated 6/6/2023, in document number 2456 are not binding on the plaintiffs and declare them as null and void, and also a permanent injunction restraining the defendant number 15 from alienating the sue scheduled properties, and also to grant permanent injunction restraining the defendant from interfering with the sue scheduled properties. Initially, when these IAs were filed, the court had issued notice to the respondents without granting granting the ad interim injunction. Aggrieved thereby, they have filed WP number 4158 of 2024 before this court. The same came to be disposed. Initially, an order of status quo was granted. Later, by order dated 7th March 2024, the same came to be disposed of, directing the trial court to prepone or advance the suit from 29/5/2024 to 18/3/2024. And the respondent number 15, that is the defendant number 15, shall file objections documents to IA number 1 by 18/3/2024. And once the defendant number 15 files his objections, the trial court shall consider and pass appropriate orders on IA number 1 after hearing both sides within a period of 1 month from 18/3/2024 in terms of Order 39 Rule 3A CPC. It is also directed that the interim order dated 13/2/2024 passed by this court in this writ petition shall continue to operate and remain in force between the parties. It is made clear that the trial court shall dispose of IA number 1 without being influenced by the findings and observations made in the interim order or in the final order passed by the court. Thereafter, the trial court had considered the respective cases of both the parties and allowed both the applications filed by the plaintiffs. Aggrieved thereby, these 2 appeals were filed.
Dismiss.
As dismissed the applications. Aggrieved thereby, the present these 2 appeals were filed. Next para. It is a specific case of the plaintiff that the deceased Pilla Doddappa had 3 sons and 1 daughter. And the plaintiff is the wife of the first son of the Pilla Doddappa. And the plaintiff 2 and 3 are the daughters of late Pilla Doddappa. And they are the undivided Hindu joint family members. The said Pilla Doddappa was granted land as he belongs to the scheduled caste. That is the scheduled property. The land was granted by the government by their caste in serial number, in survey number 1205 or SL number 1205 and Darkhast number 7205 dated 14/10/1963, measuring 3 acres of land of Linga Tira Golahalli village. Pursuant to the grant certificate was issued on 18/8/1964. And the mutation was effected in his name and entered the grantee's name. And he was in possession of the property. It is a case of the plaintiff that M.R. Srinivasa Murthy, that is defendant number 13, has no right, title, interest over the property. He had created a sale deed dated 28/11/2005 in favor of the first defendant, both based on the bogus MR 6/95 to 96. No such grant was made in favor of defendant number 12. He had created the documents and sold to the defendant number 13.
First defendant.
Defendant number 1. The sale deed dated 28/11/2005 is not binding on the plaintiffs. It is also the case of the plaintiff that M.R. Narayanaswamy has no right, title, interest over the property. And he had created a sale deed dated 28/11/2005 in favor of first defendant, based on the bogus grant. And that sale deed is not binding on them. It is a case of the plaintiff that they have been in possession of the property right from the date of grant. The family is in possession of the property. The defendant number 1 to 11 have created the sale deed dated 6/6/2023 in favor of defendant number 15. The defendant number 14 was a confirming party. He was playing fraud. And it is their case that the original owners have not executed the title and delivered the possession either to defendant number 12 and 13 and defendant number 1 and defendants number 15 at any point of time. It is a case that the defendants have created the title deeds without the knowledge of the plaintiffs to whom the property belongs. When the defendants started interfering with their possession on 16/1/2023, then they came to know about this, the revenue entries. They filed the objections before the Tehsildar. Not to transfer the kata and mutation, but without considering the objection, the Tehsildar has transferred mutation and revenue entries in their favor. As such, the plaintiffs are constrained to file the present suit seeking declaration. And also, injunction as, not to alienate and not to interfere,
Not to change the nature.
not to change, not to alienate and not to change the nature of the suit schedule properties. The defendants have filed their written statement. It is a specific case of the defendants. Where is the written statement?
Page number 158.
It is a specific case of the defendants that Sri 1 MB Ramappa is the absolute owner who is in peaceful possession and enjoyment of the suit schedule properties, and all the documents stood in his name. In the year 1988-89, the Podi and the Darkhas has been conducted by the Jurisdictional Survey Authority on the basis of the possession of the properties. Thereafter, the properties are mutated in the name of M.R. Narayanaswamy and M.R. Srinivasamurthy. That is defendant number 12 and 13. It is a case of defendant number 15 that the defendant that M.B. Ramappa had gifted the suit property and other properties belonging to him to his children under the gift deed dated 4/3/1994. And in the said gift deed, the suit schedule property was gifted to defendant number 12 and 13, and they were put in possession of the properties. And also in the revenue records also, the name of the defendant number 13 to 15 is 12 to 13 is mutated. Thereafter, the defendant number 12 and 13 have sold the property in favor of defendant number 1 by way of a registered sale deed. And the possession was handed over to defendant number 1. Thereafter, defendant number 1 and his family members have entered into a family partition through a registered partition deed dated 29/1/2016. And in the said partition, the suit schedule properties allotted to the share of defendant number 1. As such, the defendant number 1 became the absolute owner of the suit schedule properties. It is the case of the defendant number 15 that the plaintiffs are totally strangers to the scheduled property and they do not have any right, title or possession over the properties. After the purchase of the name of the defendant number 15 is also mutated in the revenue records. The trial court, after considering the case of both the parties, had dismissed the IAs filed by them, IA number 1 and as well IA number 3. While dismissing the applications, the court has observed that the plaintiff have to prove the plaint evidence as pleaded, and the defendants have also proved the contentions. At this stage, only prima facie case has to be considered. The documents on the record at this stage are in favor of the plaintiffs, are not in favor of the plaintiffs. On perusal of the entire material, the court came to the conclusion that the plaintiffs kept quiet for a long time. Defendant number 15 has also stated that if they are really the owners of the properties and having any right over the same, they could have challenged all the documents, but they have not challenged since 1994 till the date of suit. The plaintiff had relied on the photographs, MLC register, application for khutbas, letters, complaints, etc. The court felt that those do not help the plaintiff at this stage because they do not show the right of the plaintiff in respect of the properties, and hence they cannot be considered. And the court felt that the plaintiff could not make out a prima facie case and there is no balance of convenience and irreparable loss in favor of the defendant. In fact, the court felt that the balance of convenience is in favor of defendant number 15 more than the plaintiffs, and accordingly dismissed both the IAs. Then a senior counsel appearing for the petitioner for the appellant plaintiff submits that when the plaintiff has placed before the court his case and the manner in which the property is granted to the grandfather of the plaintiff, and also file the relevant documents before the court stating that that the property is allotted to them and they have been in possession of the property. It is submitted that the basis for the gift deed, the gift deed is unregistered gift deed, and basing on the said gift deed, the subsequent sale deeds have been executed. It is submitted with the senior counsel that the transfer of property by way of a gift deed can only by way of a registered document, and by way of an unregistered document, the rights of the parties, the rights in the immovable property cannot be transferred. And basing on such a document, when all these documents are the further documents are executed, it is submitted that there are no documents to show that how M.R. Ramappa is the owner of the, how he has acquired right and title to the property and how he has gifted. And basing on such a gift deed, how the other sale deeds are executed. It is submitted that when the plaintiff could make out a prima facie case with regard to the title, that by way of a grant, the property is allotted to them. And now, as it is a vacant land and it's an agriculture land, if the nature of the property is changed and if the property is alienated unnecessarily, the third party rights would be it will lead to multiplicity of litigation. The finding of the court that the petitioner could not make out a prima facie case is without looking at the documents that are placed on record. And it is submitted that in a case of this nature, unless and until the relief of not to alienate and not to change the nature of the land and not to alienate is granted by the court, it would frustrate the suit and the relief that is sought by the plaintiff. And it is submitted that the IAs ought to have been allowed by the trial court. Next para. Learned senior counsel appearing for the respondent defendant submits that though it is the gift deed is termed as it is named as a titled as a gift deed, but in fact it is a partition between the family members. He had granted the properties to his family members. According to the Lenesina Council, we're looking at the documents, what are the contents of the documents has to be looked into. Then the title that is given to the document. It is submitted that at any point of time, the name of the grandfather of the plaintiff was never in the revenue records. And from a very long time, the name of M.R. Ramappa was recorded in the revenue records. Thereafter, the name of the 12th and 13th defendant is mutated right from 1994, and they're in possession of the property. When right from 1994 till 2024, almost for a period of 30 years, the plaintiff has not even chosen to question the entries that are made in the revenue records, and has kept quiet. Now, kept quiet, and the trial court had rightly rejected the applications, and it is submitted that no grounds are made out seeking interference with the well-considered order passed by the trial court. Next paragraph. Having heard the learned counsel, the senior counsels on either side, there is the material on record. The suit is for declaration, injunction, and also a declaration that that is a owner of the property, and the sale deeds do not, the sale deeds are executed with the defendants in respect of the properties do not bind the plaintiff. Undisputed facts of the case are that according to the plaintiff himself, right from the year 1994, the name of the defendants is as per the revenue records, it is the name of the defendant that is mutated. According to the plaintiff, the name prior to that, the name of the plaintiff's grandfather is there. And there is also no dispute about the fact that a gift deed is executed in the year 1994. A gift deed is executed in the year 1994. Now, it is a contention of the plaintiff that basing on the said gift deed, which is an unregistered document, no rights will flow to the defendants, and they cannot execute the documents. It cannot be said that right from 1994 till 2023 or 24, till the suit is filed, they are not aware of the revenue entries. Even if it is an agricultural land, there is no tax here in Karnataka.
Tax is there. No tax.
No tax for the agriculture.
It is there, madam.
Huh?
This tax.
It will be there.
Kandaya, madam.
Huh?
Kandaya will be there. Kandaya we have to pay.
Kandai is exempted now.
We call it the sister in revenue they have to pay. What do you do? Agricultural land, still they have to pay the revenue for the same. It cannot be believed that right from 1994 till 2024, they are not aware of the said revenue entries. It is also a subtle law that the entries in the revenue records do not confer any title on the party. But at the same time, at the threshold, when the court is looking at a prima facie case and balance of convenience and the irreparable loss, court can only ascertain from these facts with regard to the possession of the property. From the material on record and from these documents, from the revenue entries, it is clear that right from 1994 till now, the revenue entries are in the favor of the defendants. In favor of the defendants. And it is submitted that initially as an order of status quo is granted, this should be continued. In order of status quo is a double-edged weapon, and it would unnecessarily create litigation and rift between the parties. And particularly from looking at particularly having perused the entire material on record, this is not a case where a status quo can be issued. In the considered opinion of this court, the trial court rightly considered the documents on record and rightly passed an order whereby the court has observed that the ingredients for grant of a injunction are not in favor of the plaintiff, and in fact the balance of convenience lies in favor of the defendant number 4. Hence, this court finds no reasons to interfere. Accordingly, both the appeals are dismissed. Give the next 2. In this also status quo granted earlier.
Yes, similar.
Same one.
Same set of facts.
Suit is 80 of 20.
You are dismissing.
2799 of 2024 connected with MFA number 2800 of 20. Hello?
Now the next two numbers are 2799 and 2800.
Yes, ma'am.
Yes.
The present two appeals are filed, agreed with orders passed in I number 1 and 3, invoice number 80 of 24, dated 15th April 2024. The appellant before this court is the plaintiff in the suit. The suit is filed. Documents are also same in this also.
Similar documents, my lord.
Grantee and survey number is different.
Only grant.
Grant is dated 14/10/63 alva.
Grantee name
The,
and
to
survey number.
declare
is
the
Nagaraj Appa alias Nagappa.
suit is filed seeking declaration that the plaintiff is the absolute owner of the suit scheduled properties, to declare that the sale deed dated 28/11/2005 in document number 4313 and sale deed 28/11/2005 in document number 4281 and sale deed dated 6/6/2023 in document number 2456 are not binding on the plaintiffs. Same in the like earlier, initially when the stay is not granted, they have come before this court and this court has disposed of. What is the writ petition in this suit?
Same.
Same.
Same, in the same writ petition, earlier, same as is,
Where are it?
there must be a separate writ petition.
Separate writ.
Separate writ petition.
What is the number?
4170 of 24.
Writ petition is 41.
70 of 24.
And the written statement is also same.
Same.
Same, the defendant filed the written statement. Same as it is. Only the plain scheduled property will change, that mentioned in both the cases. Yes.
Great.
What is the matter? We'll do one thing, we'll complete till the only this MFS of 2024 will complete and then we'll take to the debate.
Yes. Sale number 18. TV, petitioner, Rajesh Shafian.
I will receive the application for temporary injunction, my lord. I will file my objections. Kindly have it on Monday, my lord. In the meantime.
Post on Monday. Wednesday. Post on Wednesday.
Wednesday.
Sale number 19.
I appear for
Manushankar.
appellant in this case.
Yes.
Plus, appellant filed this suit for the relief of mandatory injunction, directing to the defendant to remove the illegal encroachment of 3 feet of common passage, my lord.
What is the order passed by the trial court?
The trial court has dismissed the 13 application under order 13 rule on 2, my lord.
Will issue notice to respondents.
Sale number 20.
Registry is directed to issue notice to respond. It's 20.
T. Sheshagiri Rao 20.
No representation. Post this matter on 9th of September.
Sale number 21. Ravi Prakash V.
I pay for the appellant in this matter notes. Suit for specific performance. Lord, sir. It is a plaintiff's appeal, 21. My lord, sir, the plaintiff and the first defendant is the owner of the property.
You're the plaintiff.
I am the plaintiff. The first defendant, the plaintiff and the first defendant entered into an unregistered agreement of sale. He has received, there are 2 agreements. One agreement is pertaining to 3 acres of land, and on the same day, another agreement has entered with respect to 1 acre of land. He has in total received 50 lakhs as on the date of agreement. Subsequent to that, my lords, when we approached him for executing of registration of the sale deed, he informed us that one of the suit filed by his brothers is pending, and in that case, the honorable trial court has passed an order of not to alienate, and as such, they could not execute the sale deed at this point of time. Subsequently, my lords, the defendants in the other suit, that is his brothers, they also came together and they said that they will going to execute the sale deed immediately after the.
Please come, pose this matter for the other court after obtaining the necessary orders from the Honorable Chief Justice. Yes,
Cell number 22.
For the appellant,
yes.
in the plaintiff appellant lots, suit for bare injunction lots,
Hmm.
restraining the defendant from dispossessing the plaintiff tenant by forceful means.
Hmm.
Lots, after the appearance of the defendant, the honorable court hears the matter and grants an interim order. Lots. Subsequently, the application is heard. Lots, the written statement is filed, in which he clearly admits that the plaintiff is a tenant of the defendant.
No, please come again. What is the suit for?
No, suit is a bare injunction suit.
Hmm.
Bare injunction suit requesting for a direction not to dispossess the plaintiff by force.
Hmm.
Not to dispossess him by force. That's the only prayer. The written statement is filed wherein the defendant admits that I am a tenant. I am paying the rents. Lords, he also admits that there was an agreement in 2014. Lords, the honorable trial court, only on the ground that the lease deed is not produced, the interim order is not granted.
Come to the order.
Lords, may I draw lordship's attention to page number 21.
Let's see the written statement.
Lords, written statement, page number 35. If I may draw lordship's attention to paragraph 3.
Hmm.
I quote, that the averments made in para 2 of the plaint that he has been a tenant in respect to the property bearing number 2, Maurya Mansion, First Cross, Gandhinagar, Bengaluru, 56009, which is more fully described in the schedule hereunder, referred to the scheduled premises since 1979 and has been very prompt in the payment of rents, is not within the knowledge of the defendants that the plaintiff is a tenant in the suit scheduled premises since 1979. Further, as claimed by the plaintiff, he is not regular in the payment of rents to the defendants. Further averment that initially the plaintiff was paying a monthly rent of so and so. Lords, if I may draw lordship's attention to paragraph number 4, Lords. The averments made in para 3 of the plaint that he has been in uninterrupted possession, peaceful possession, enjoyment of the suit scheduled premises as a tenant under the defendant number 1 and has been exercising the rights as a tenant over the suit scheduled premises is true. If I may draw lordship's attention to paragraph 5, Lords. The averments made in para 4 of the plaint that defendant number 1 and his son contacted the plaintiff in the first week of March 2024 and called upon him to vacate the suit scheduled premises is true. Para 6, Lords. It is submitted that the defendant number 1 was desirous of letting the scheduled premises on lease. Upon coming to know the same, the plaintiff approached the defendant number 1 requesting to let out the suit scheduled premises for the office and commercial
Come
purposes.
to the order.
Lords, Lordships, if I may draw lordship's attention to paragraph page number 16, Lords.
Page number?
16, the impugned order.
Yes.
The interim order.
Hmm.
That's page number 17, orders on IA number 1. Plaintiff has filed IA number.
No, come to the reasoning.
Lords,
Come to the
page
reasoning.
number 21. If I may
Para
draw lordship's attention to para
Para
8.
8.
I have perused the list of documents produced by the plaintiff, that is certified copies of the bank statements from 1/4/2022 to 14/3/2024 to show the payment of rents, Xerox copy of tax invoices dated 12/3/24 towards purchase of office materials raised on the plaintiff, Xerox copies of various agreements entered into by the plaintiff from the suit premises with various parties, and the plaintiff have received communications from various authorities, including Doordarshan, Prasar Bharati, addressed to the plaintiff at the suit scheduled premises, Xerox copies of electricity bills in respect of the suit scheduled premises, which is paid by the plaintiff, Xerox copies of the photographs taken by the plaintiffs of the suit scheduled premises taken on 14 so-and-so, and the compact disc consisting of the aforesaid photographs taken by the plaintiff of the suit scheduled premises.
The present appeal is filed. Agreed with the dismissal of I number 1. Wherein the plaintiff has sought for injunction restraining the defendant from dispersing the plaintiff from the suit scheduled process. It is the case of the plaintiff that he is a tenant in the said premises belonging to the defendant. And now forcibly is trying to interfere with the position of the plaintiff. The defendants have also filed the written statement agreeing the fact that the plaintiff is their tenant, and also a request is made to vacate the premises. The trial court has dismissed the application only on the ground that the lease deed is not filed before the court, considering the fact that as on the even considering the admission made by the defendant that he is a tenant and is in possession of the property. There shall be an injunction restraining the defendant from interfering with the injunction restraining the defendant from dispersing the plaintiff from the suit scheduled property. The registry is directed to issue emergent notice to the respondent.
Milords, if I may submit, Milords, they are on caveat, Milords. In fact,
They are on the caveat.
they are on caveat.
Then why you have not served?
We have served, Milords. We have served and their name is also reflected in the list, Milords.
And though the caveat is filed, the caveator's name is printed in the list, but there is no representation on their behalf. Post this matter after, gives some date after 2 months. Yes, next.
Much obliged.
This 23, who appears? We'll take it up
The
sometime.
memo of calculation today,
File
it is
it.
going to come for.
Just I received the copy.
It may be taken on
23, post this, today it is submitted that the memo of calculation is filed.
Told.
Post this matter on 10th of September.
Not any earlier date, my lord, since it is a limited issue of maintenance. Interim order is there since 22. My only thing is we can put a quietus to the entire thing.
29th.
Yes.
Grateful.
Yes, next.
230 matters. Till number
My last is 29th, it's maybe 30th, Milord. 20th is ceremony. 30th.
30th. Yes, next.
till number 47. 230 matters. Rajesh Gowda. for
Case.
appellant. Shankar Gowda. for respondent.
Yes,
Respondent member, 1 year, my lord.
yes,
Why
Mr. Gowda.
So Rajesh Gowda.
Close the window. Close that window.
There is some error in their office only. Rajesh Gowda, sir. He's unmuted some technical problem.
Next matter.
Till number 48. That is
Same
also.
connected, madam.
Same
Kindly
connected.
pass out, madam.
Passover. What Passover at 4 o'clock? Post this matter on Monday at 2:30. Monday, there is any 2:30 list? Wednesday 2:30. Yes, yes.
Till number 49. Lakshmikant K. S.V. Prakash.
Here, Milord.
Yes.
The son, Milord, has claimed a maintenance against the father.
How much is granted?
8,000 is granted.
Uh,
Father is aged about, Milord, now 69 years.
Son?
Son 23 years. 24 years now.
Hmm.
Is, Milord, according to this, Milord, there is
It is this RPFC of 2020.
2020.
So as on the day, what was his age? You might be 19 years.
No, 21 is because, Milord, is that they are claiming that he is an unsound mind.
Oh.
For that, Milord, they have not produced any medical records.
According to you, is not.
No, he is capable, he is present before this court, Milord, he is outside.
Is?
He is present before this court, Milord, he is outside the court, Milord. And the one thing is, Milord, may kindly see the order dated.
He's saying that your client is present outside the court. He's saying your client is present outside the court. Is it correct? Is the one?
That person.
My lord, mentally retarded. He is not capable of doing anything his own. He required help of
You
somebody.
take a break. Yes, you argue.
My submission is that, Milord, the
the second wife of the petitioner, my lord, is having two children. Among them, my lord, one person is, my lord, one son is working as a police constable, my lord. May kindly see the order dated, my lord, on in the humanitarian consideration, my lord, on 23/20/23, my lord, I keep him before this court, my lord. And I advised him, my lord, to keep deposit some amount, that 10 lakhs, my lord. For that, my lord, he agreed. Thereafter, my lord, without my knowledge, my lord, they have prepared one joint memo, and wherein, my lord, they have written whatever they want. And when I was in another court with my colleague, my lord, with junior colleague, my lord, without permitting to read that memo, my lord, I took the signature and filed it.
Whose signature they have taken?
My colleague representing on my behalf.
No, but
And
yeah, ultimately that memo should have been signed by your client.
no, client also present, who is, my lord, aged about 69, 70 years. He doesn't know.
What is the memo?
Joint memo, that settlement, my lord. That year, my, the
No,
son
as
of,
per that memo, what is the amount?
the same amount, but my lord, the amount should be deposited in his name and as well as in the name of the petitioner who is represented by the guardian. And in that, my lord, they mentioned that amount can be withdrawn at any stage. But my intention is that, my lord, the second son of the petitioner intention is that, my lord, that amount should be keep long time, and you should this thing. For that, my lord, he has obtained a loan and he about to deposit, but the thing was that, my lord, he could not able to deposit. May kindly produce the order dated 23/20/22, my lord. In this
23?
2022. 23/20/23. The son of the petitioner,
Dated by which court?
this court,
23/2023.
23/2023, please.
It's there.
The son of the petitioner, Shri Santosh Kumar, who is presently employed in cybercrime police station, submits that he is willing to deposit sum of rupees 10 lakhs in his name as well as in the name of the respondent. And the respondent can receive the monthly interest towards his maintenance, that apart from the claim of the respondent in the property of the family. For that, he is agreed. Now also, my lord, he is ready to deposit that amount. Subject, my lord, the amount should be deposited in his name.
Why, what he says is fair.
My lord, your lordship kindly see the conduct of the.
Not conduct. What he is saying is only one thing. No, that amount cannot be withdrawn.
Lord,
It cannot be withdrawn. You can keep it and have
but I
interest
have
for his
agreed, and this honorable court, my lord, dispose of the matter in terms of this, what my learned friend said. Your lordship kindly see the judgment of this court.
Please give that.
No, the judgment is also, may kindly see the joint memo. No, madam.
Your
Without
lordship
supplying the copy to me.
Order passed on 10th April 2023.
Correct.
10th April.
10th April 23.
It was disposed and he has filed an application for regarding that order.
10th April. There is no such order of 10th April.
I pass on this judgment of this
Separate order,
court.
wait, separate order.
What it says? Order dictated, RPFC is disposed of. Where is that order? Take that.
My lord, in terms of the joint memo only, I pass on joint memo also. My lord, he
has not
complied the order of this court and also joint memo.
Since the compromise is just and proper, the same is accepted. So and so. This petitioner has deposited in the name and has permitted the respondent to withdraw the interest earned on the deposit. It is stated in the compromise that even the respondent requires any amount to move any genuine need or necessity, he may apply to the family court. That is also correct. What is wrong in it? No, if you require.
Now may kindly see the joint memo. Joint memo was filed in my absence and in the absence of my junior.
No,
in the
let
presence
us not go into all
Please.
this. Please understand.
Please, Your Honor.
Now, what you say is you're ready to deposit that money.
That money in the name of the son of the petitioner as well as the respondent, madam. The other son is there, madam.
What you will do? Please wait 1 minute. Yes.
My lord, the amount should be deposited in the jointly, the son of the petitioner as well as the respondent, madam. And he has agreed to withdraw the interest, whatever the earned interest, madam, every month or quarterly or any time, madam. For that, my lord, he is agreeing. Without contacting me as well as my lord.
No, why should we in your name? Why not in his name?
Because, my lord, he is now representation only, my lord.
No, what is this order passed? on that amount, whatever is the interest that will withdraw the interest.
Please.
If at all they require any amount for any genuine reason, for any health reason or whatsoever, they should file an application before the family court.
Please, my lord.
And family court will decide it.
Family court, in the family court, my lord, I was not the party. The son was not the party. Son voluntarily
Then we'll record that whenever such an amount has to be withdrawn, notice should also be given to you.
Please, the amount be deposited in the name of the petitioner as well as the son of the petitioner as well as the respondent. If it is, my lord, I am ready to deposit the amount because tomorrow, because if the court permit, my lord, to withdraw the amount for the genuine reason to the respondent, that can be withdrawn. That amount be in the name of the both the son of the petitioner as well as the
You
respondent.
can also withdraw.
No. That condition may be imposed. I will never withdraw it.
Please, my
Till
lord,
the-
earlier joint memo, my lord, this matter may be disposed of. My lord, the conduct of the
Let us,
petitioner
we
here.
do not have time for all that now. So that with that modification,
Please.
we'll pass the order.
My lord,
Where is it? Then what will happen to the joint memo?
Joint memo, he has not served the copy also. At 4:30 PM, my lord.
Why it is again listed today?
For the reasons that, my lord, since it is against this, my lord, the joint memo was prepared and in my
Writ
My lord,
petition is,
yesterday, my lord, it is
writ petition is disposed of. Why again? Why it is
order has
listed?
already recalled.
called.
Order has
My lord,
recalled.
he
Order is recalled already.
called,
When is it recalled?
That long back.
your lordship,
By the order dated
Oh,
7/12/2023.
Is already recalled.
Recalled.
my lord, the petitioner
Now,
here in.
now I'll record both your contentions. And the amount would be in the name of both the petitioner, the second son of, who is it?
Who is Santosh Kumar.
My lord, no, my lord, I will convince your lordship, my lord. My lord, second son born out of second wife, not the first wife. He is
Who is
the,
giving the money?
my lord, he is,
Second son is giving the money.
Please.
no,
Yes,
no, my lord. the
recorded in the
petitioner-
order.
The petitioner here in,
No.
Second son who is working.
He is, my
he is
lord.
giving them, please understand, whoever it is.
Please.
Now, no, he can't withdraw the money.
Please.
He can't withdraw the money. And you cannot withdraw the money except the interest.
Please.
And if at all you want, you have to go before the court. Because the account that is in their joint name, whenever you want to withdraw the amount also, notice to father is compulsory. That is what we'll record and dispose of. And within how much time you will deposit?
If it, my lord, within
earlier, my lord,
within 1 month.
joint memo, my lord, he agrees to deposit the said amount in the name of the respondent herein and the guardian. My lord, your
That
lordship
is, my
kindly
lord.
appreciate that, my lord.
Because there
20
is no time.
Please,
If
my
you
lord,
want it, I'll take it some other time.
27 years, my lord, my lord, his aunt, my lord, looking after it. Till today, my lord, he has not paid single pay. Single pay, your lordship
His
kindly
age
see
double.
the-
When you're getting 10 lakhs, what is this argument now? Ultimately, you're getting the money and also you're going to have the interest as per the earlier joint memo. Though it will be in both the names, he cannot withdraw. So we can look at it, the court can look at it that he's trying to protect the interest because he's a mentally unsound. What is wrong in it?
My lord, till today, my lord,
We'll pass some other day.
Please.
It's already 4:50. No, it's not going to end with,
my lord,
when do you want?
next week.
Next week. And
Well,
next week, with no discussion, we'll pass orders. Yes.
One submission, my lord, 47, 48, interim order has to be extended, my lord. Sorry, my lord.
Now it is.
47, 48.
Now it is working, your internet.
My laptop is also, I'm working in laptop also,
Yeah.
it's not working.
That matter, no, that 231.
47, 48, my lord.
Interim order earlier granted is extended. Yes, next.
Great, my lord.
My
Great.
lord, date may be fixed, my lord.
14/8, sir.
Yes.
14/8.
Yes, next.
Serial number 24. Preliminary in B group 24.
24. Request a time, my lord.
Lords, kindly
Get
see,
for
Lords,
petition.
kindly see the order of Lords,
Otherwise-
last date, Lords. They said settlement talks is on.
Lord, there is no settlement, my lord. They are supposed to go ahead with the matter today, my lord. Lord, the matter,
Petitioner submits that there is a likelihood of settlement, but the settlement is not or not from the last 2 days, the same submission is made.
No, he's held up in some other court. Madam, he's requested me to appear and.
let's
just,
vacate the interim order, my lord. They will come running, my lord, today itself.
Monday it may be taken up, my lord.
Monday. Monday, finally, no further adjournments will be granted. Not Monday, there are so many matters, my court officer is very much bothered if I say Monday, Tuesday,
48.
yes.
Problem.
Serial number 25. S. Ramurthy. 25 S. Ramurthy.
Of the petition.
Akshay B. Shetty.
Yes,
This is wife's petition, my lord.
Hmm.
She was the respondent in the MC case.
seeking enhancement,
No, this is only, an application was filed by the wife, power of attorney holder of the wife, to permit her to continue the proceedings on behalf of the wife,
Hmm.
mother,
Hmm.
daughter.
Hmm.
And Order 3 Rule 2 application was filed.
Hmm.
Order 3 Rule 1 and 2 application was filed under the.
Please come to
CPC.
the order.
And yes, the interim order that is in tune.
Page 34, my lords.
Page,
Page 34, my lords.
Hmm.
My lords, this is Annexure C,
See.
my lords. The order is in page 29.
It's a handwritten order, my lord.
The transaction is in page 29.
Page
Page?
25.
29, my lords. It starts from 25, but the operating portion, it is in page 29.
is allowed in part, power of attorney is accepted only to the extent doing acts respondent except giving evidence and other acts which required personal parent. What is wrong with this order?
My lord, the petitioner, my lord, is the power of attorney. I mean, she has filed this petition. She is the power of attorney holder of the daughter. Daughter went abroad. And before
Who filed the MC?
the
My
power of
lords, the
attorney
husband
holder
has filed, the
it.
respondent in this
Hmm.
case, my lords.
Respondent. Before she went to Canada for pursuing further studies, and before going there, she had given the power of attorney to the mother.
Hmm.
And mother has filed this application. Your lordship may kindly go through this, this application.
When
File.
her presence is required, she has to come wherever she is. That is what the court said. Court said, you can represent her. Whenever her personal presence is required, that time you have to come. At that time, your daughter has to come.
The leading evidence is a right under section 118 of the Evidence Act. And anybody can depose under 118.
In that case, nobody has to come to the court.
No, that is what series of decisions of this honorable court, cutting out decisions are there, my lord. where
There are
there's a-
judgments on that side also. Saying that the party has to be present before the court.
That is as to the extent what her knowledge is, she can speak. And
Oh, no, from now
totally-
onwards, what will happen is both wife and husband, they'll file cases and they'll be somewhere. GPA will be given to the parents and they will be fighting here without coming to the court, no evidence, letting no
And
evidence.
even video conferencing also is not allowed.
That you
here.
can file an application.
That is not done here. That is also prohibited now.
May I?
Yeah, under this order.
Where did they say?
Your lordship may kindly see.
No, the application is only to that limited extent about your GPA. Whether you can represent her as the GPA holder or not. Why will the other things will be considered in this about the video conferencing and all?
No, that is what.
Where is that? Please come to
the
that.
Intuned order, my lord.
Submit, my lords. My lords, what has
This,
happened is, my
point of consideration that has been done here itself is not correct, my lord. Your lordship may kindly see.
Please read from.
I will read the order.
Page number 26.
Page 25. Application is filed seeking permission to appoint mother of the respondent as power of attorney holder. That is not so. Actually, mother has filed this.
Yes, yes.
The POA holder has deposed that her daughter is pursuing post-graduation in Canada and cannot appear to give evidence based to allow the IA. The counsel for the petitioner denies the amendments and submit the respondent's mother cannot give evidence on personal acts placed to and acts placed to reject the IA. Heard from the counsel for the respondent, the following points arise for my consideration. Whether the power of attorney holder has personal knowledge about the incidents in between petitioner and the respondent. That doesn't arise at all, my lord. Because the application is for permitting the mother to prosecute the proceeding. That is all. That is IA.
My lords, the dispute is between husband and wife, my lords. It is between four walls, my lords. My lords, what has happened in this case is, my lords, she has filed, my lords, assets and liability, my lords. And we got to know the information that she has not filed the detailed thing, and my lord, she has hoodwinked
Page
some of the things.
34 is the
She didn't-
application, my lord.
She didn't come to the court with clean hands.
Page
That is the
34
reason,
is
my
the
lords, we
application.
went on to file a contempt petition, my lords, on 17/8/2023.
I may be
Subsequent to which,
allowed
my
to
lords, this
address
writ
the
petition
arguments,
was
my
filed.
lord. I may be allowed to address the arguments, my lord. Here, and the point for consideration itself is not correct. And in the reasoning, my lord, page 26.
Please come to your applications.
Yes,
I
my
have-
application is application under Art 3 Rule 1 and 2. It is page 34, my lord. Annexure C. For the reasons stated in the accompanying affidavit, the applicant respondent says that the court may please to grant leave to represent the respondent through her authorized agent, that is her mother, by name Mrs. Lily
Yes.
Corda, to whom the respondent has already given general power of attorney dated 17/11/22 in the above case, and to grant etc. That is the application.
My lords,
Yes,
one submission.
And
let him come.
the reason assigned, my lord, is at page 26.
Yes,
The petition is filed for resolution of marriage harmonized in between the petitioner and the respondent, for which harassment, cruelty is the ground. Order 3 Rule 2 permit the parties to appear to any person by proper authorization. It is also a settled law. It is also a settled law that, as held in one of the recent authority, that judicial officers are spending precious time in passing a detailed order on such applications, and directed all the trial courts to allow such IAs without calling for objections, and decide finally whether such POA holder had personal knowledge or not at the end of the case during time of judgment. This is what is the observation in the first para.
yes.
What has happened subsequently? It is given a contrary, my lord. Ultimately, well, the court comes to the conclusion that some matters which are within the knowledge of the husband and wife, that cannot be deposed by the mother. So on that ground, the ultimate order is, I have to say with allowed in part, power of attorney is accepted only to the extent of doing acts on behalf of the respondent, except giving evidence and other acts which required personal presence of the respondent.
Yes.
And in a similar case, my lord, this application itself was not required to be filed, because the power to examine the power of attorney holder emanates from Order 3 Rule 1 and 2 itself. There is no need for filing this application. In identical case, my lord, the coordinate bench of this court
Yes,
has
take that. Yes. Yes,
So ultimately, whether the evidence to be acceptable or not, what is the value of the evidence that should be, that is to be given to her evidence, that is to be ultimately decided by the court. And it is for the court to subsequently decide whether it should be, what is the value that could be given or not.
yes.
So this application itself was uncalled for, and it was not necessary to have been filed. And when once it has been filed, and the reasoning adopted by the trial court, my submission is it is not in accordance with law.
Yes.
And permitting only the power of attorney holder to do other acts, and prohibiting her to give evidence. I have come here because that is not permissible under law. That 118, that is Justice Kumar's judgment is there, my lord, identical question.
Yes. Yes.
Here, the- para 8.
Yes.
From the above, it becomes clear that it is not obligatory on the part of the party to a litigation to appear in person unless the law so requires. Because in family court, where certain persons are not permitted to, a power of attorney is not permitted to appear. So in such circumstances, it may be compelled, but not otherwise. The question of granting permission to a party to prosecute the matter to a power of attorney holder or a pleader would not arise. However, the court cannot prevent a party from prosecuting the litigation or defending it to a power of attorney holder or a pleader, only in some exceptional cases such as the case arising, para 8, my lord.
Yes.
The family court, where an advocate cannot appear as a matter of right and can appear only on the permission granted by the court, the party has the right to be represented by a power of attorney holder or a pleader. So what I ultimately, my right of getting examined through video conference also is not allowed in this case.
Where is it?
That is last.
Not the application you have filed. Why would the court pass an order? And I
Yes.
have not found anything in this order.
Yes, we have only sought for permission to, my
That's it.
application
On that
itself
court
is
has
only to
passed,
that extent.
No, saying that even the request for video conferencing is rejected is.
No,
without
that
any
is
basis.
uncalled for because the
Yes.
court has prematurely,
Where did the court say?
yes.
The court has not said so. That you are not entitled for a video, you cannot be examined.
No, this is one pair. Several modes are now prescribed. That is the several modes are now prescribed to assess the witness who is residing out of India also. The petitioner also appears to be the residents of Kuwait as stated in the objection. Thus, the power of attorney being valid to do other acts except giving evidence. So she is prohibited. Mother is prohibited.
Yes.
It is not permissible under law. She has got a right and
I'll
I
record
draw your lordship attention to 108 of the evidence that now corresponding
You
to
relied on a judgment and the judgment deals with that also, 108 of the Evidence Act.
180, yes,
It is already recorded in the order.
yes, that is there.
Yes. Let him suffer.
And now corresponding to section 124
Yes.
of the Bharatiya Nyaya Samiti, all persons shall be competent to testify unless the court considers. That is what the judgment has said. So power to lead evidence to the mother emanates from 108, 124. And therefore my submission is that the order in June requires to be correct.
Yes.
Lords, the petitioner, my lord, she has filed assets and liability before the family court, my lords. That was not in accordance with law. Lot of information were contained, my lords. That is the reason I have filed contempt petition. Also, my lords, there are about 40 documents, my lords, that is to be confronted before the court. Such is the case, my lords. I have video conferencing. It will not be possible, my lords. Also, my lords, my senior has.
On video conferencing, where is this is nothing to video, nothing connected with video conferencing. It is only about a petition filed by the father to give evidence as that's it.
Please, my lords.
Oh.
And also, my lords, when this
Whether
petition
it is
was.
feasible or not, at an appropriate application, the
Please, my
court will
lords, when
decide.
this petition was filed, my lords, the petitioner, she was in Canada via study visa, my lords. And the visa permitted, my lords, only from 15/12/2022 to 30th/4 of 2024, my lords. Now that, my lords, the visa, I mean, the study visa, it is also expired, my lords.
Yes. Please come. Where do you get the IA numbers and all from this order?
I had two at page 34, my lord,
Agreed by the orders passed on. I number?
IA number 2,
I number 2 in
34, annexure C.
in MC number 58, 2022. Dated
That is dated 19/4/23, my lord.
19/4/23. The GPA holder of the wife is before this court. The mother of the wife had filed the present IA to grant leave to represent her daughter. The wife had filed a petition that the leave may be granted to represent to her authorized agent, that is her mother, to whom the wife had already given general power of attorney dated 17/11/2022. In support of the said affidavit, it is stated that a GPA was given on 17/11/2022. The daughter had got admission for pursuing post-graduation in cybersecurity course at Canada, and she cannot come to the court and give evidence. Hence, the GPA deed is given in a favor. And the court had, under the sought leave of the court to give evidence as to proceed in the above case. By order impugned, the court had observed that if the respondent is permitted to give evidence to her mother, the consequences have to be seen. The petition is based completely on the ground of desertion cruelty, where question of intimate relationship in between the husband and the wife are involved. A daughter might have explained each and everything to her mother, but certain facts will be within the four corners of the house, which the power of attorney holder might not be aware. Even otherwise, the mother of the respondent, mother of the respondent, the mother of this wife cannot be questioned regarding the intimate relationship or such coincidence between the wife and husband. The necessary facts required by the petition, required by the husband cannot be elicited from the GPA holder. Hence, the court has opined that the mother of the respondent would be a proper witness to the incident, relation of the petitioner, the ground. No, not that. The repetition of the relation of the petitioner respondent cannot be expected to have personal knowledge about some personal issues which would have been otherwise in other cases other than matrimonial issues. And the court felt that the power of attorney holder, power of attorney holds good for the attorney holder in performing other acts except to give evidence. Court also observed that several modes are now prescribed to access the witness who is residing out of India. And the wife also appears to be the petitioner mother also appears to be the resident of Kuwait as stated in the objection. And accordingly, the said application is disposed, allowed in part, and the power of attorney is accepted only to the extent of doing acts on behalf of the respondent, except giving evidence and other acts which require personal appearance of the respondent. Land counsel appearing for the petitioner submits that the order that is passed by the trial court, whereby the mother was not permitted to give evidence on behalf of the daughter, is contrary to settled law. We had relied on the judgment of this court in red petition number 200500, the coordinate bench of this court in WP number 2005002022, dated 1st June 2023. Parent. It is observed, it is observed by this court that in terms of Order 3 CPC, any appearance or application court may be done by a party in such court or by his recognized agent or pleader. In terms of subsection 2 of Order 3 of the recognized agency is defined to be person holding power of attorney authorizing him to make such appearances, applications, and act on behalf of a party, as also persons carrying on trade or business for and in the name of the party to a proceedings. The court further observed that insofar as veracity or otherwise of the evidence which is led, the same shall have to stand the test of the Indian Evidence Act, which would include personal knowledge of the facts, as also stand and test of cross-examination, as also rules relating to appreciation of evidence as per applicable law. And the court is of the considered view that the power of attorney cannot be shut out or prevented from reading evidence on behalf of a party to a proceeding. Hence, the court has said that no application for permission is required for the power of attorney to lead evidence on behalf of a party. The question of rejection of such application on the ground that no grounds have been made out by a power of attorney to lead evidence is not sustainable. Relying on the said judgment, then counsel submits that the power of attorney holder has every right to lead the evidence in the trial court by allowing the application party has passed an order which is contrary to law. Then he had relied on the judgment of this court in Sajida Banu versus Halima Banu and others reported in ILR 2015 Karnataka 635. Where the court has observed that the courts cannot prevent a party from prosecuting the litigation or defending it through a power of attorney holder or a pleader. Once the power of attorney holder enters the witness box and gives evidence, whether that evidence has to be acted upon, whether it is a direct evidence or hearsay evidence, is to be decided by the trial court at the time of appreciation of the evidence. On the ground that the power of attorney holder has no personal knowledge of the case, he cannot be prevented from entering the witness box and from deposing. Basing on these judgments and relying on the it is submitted that the said finding of the court is contrary to the provisions of the Evidence Act, and it is submitted that the court ought to have allowed the application. When counsel appearing for the respondent, husband submits that this is a case where the husband is seeking divorce on the ground of desertion and cruelty. To succeed in the case, he has to elicit the personal information from the wife earlier when she has filed the statement of assets and liabilities. As she has filed a false statement before the court, he has initiated the contempt proceedings and And there is voluminous record which has to be subjected to in the cross-examination. And only the wife can, it can only be elicited if the wife is cross-examined. And the court had rightly passed an order. Next, having heard the counsels on either side, there is the material on record. There is no dispute with regard to the rights of the power of attorney holder to lead the evidence, and no dispute about the judgments that are relied on by the learned counsel for the petitioner. Both the judgments that he has relied on are arising out of of a civil suit. And the law that is laid down in those cases cannot be applied to the facts of this case. The, as rightly observed by the trial court, in these kind of cases where the GPA, the mother can pursue the matter, and she can also be a witness, and she can lead the evidence before the court. But when this is an MC filed by the husband, and with all the allegations, and to elicit the same from the wife, and in these kind of personal matters, the presence of the wife, the wife has to be cross-examined. Then with regard to the pursuing her studies in Canada is concerned, the court can, the GPA holder can file appropriate application in case if it is inconvenient to the daughter to come to India. But the argument of the learned counsel that the daughter will not appear before the court and she will only lead evidence as she is entitled to cannot be appreciated concerning the allegations, and it's a matter pertaining to matrimonial proceedings.
The cost of the respondent, my lord,
Huh?
the video conference at the cost of the respondent.
No, that I'm not passing any order. When required, you file a petition.
It is 7
that
days
is-
marriage, my lord.
Yes, next. Dismissed. Yes, next.
26 adjourned, cell number 27. Muniswamy Gowda.
For the respondent in this case, the order impugned in this petition was impugned by me in WP 19102 of 24. This honorable court heard both the sides and disposed that petition on 25th of July 2024, your ladyship. The impugned order was upheld therein, and the very same order has been challenged.
Not upheld. it
Not
has
very
been
same
dismissed.
order. That
very
is with regard to the visitation, that is a maintenance case.
Your ladyship,
Even
it
that,
was on
this
visitation.
was also, my lord, that was dismissed. Their writ petition was dismissed.
But there, where you questioned if I remember, you have questioned that, that whatever is the visitation granted, you have questioned.
Yes.
The
That
interim
have-
custody was
that's
questioned,
not-
and so the operative portion of the order's not been uploaded yet
No,
to place before
no,
this
no,
honorable
they have
court.
questioned the visitation that is granted to you.
Yes, my lord, one,
That is dismissed.
that is dismissed.
That is dismissed.
The order was upheld. The impugned order was upheld.
No,
So
my lord.
order,
It is not upheld.
Not upheld,
No,
it has
that
been
is upheld.
dismissed.
the impugned, the order
That
impugned here,
The order is upheld, your writ petition is dismissed.
Dismissed.
that part was disposed of.
Ah.
It was disposed of upholding orders on IA 3 and 11. IA 3 and 11 has been, the orders on IA 3 and 11 have been impugned before this honorable court in this petition right now. Again, your ladyship.
In your petition, that is upheld. That impugned order is before this court from the point of view of a husband,
Certainly,
the
certainly.
father. Now we will see it.
It was my respectful submission, if on certain grounds
On
an
that
order is
day-
upheld, it cannot be modified on other grounds.
It can't be, that can't be an argument. But where is the order?
My lord, the operative portion of the order is at page number 100. my lord.
Now, in your petition, I cannot decide his right. Isn't it? And in a petition filed by the wife, I cannot say this order passed by the court granting visitation is wrong. I'll give more visitation to the father who is not aggrieved.
Lady-
So that analogy you can't apply in this case. Where is the order?
My lord, it's page number 97, my lord, the operative portion is at page number 99.
Yes.
My lord, I'd asked for visitation, right?
Where is the order?
My lord, page number 99. My lord, the operative portion is at page number 100.
What it says?
My lord, the respondent is hereby directed to hand over the interim custody of twin children Ira and Raghav to the petitioner on every Saturday between 6 PM to 8 AM, 8 PM, to even enable him to exercise visitation rights. My lord, only 2 hours has been granted. My lord, that now I am asking, my lord, that to enhance.
What are the age?
My lord, now they are 4 years. They're school going
They're 3
children.
years old. Your ladyship.
They are school going.
No, at what time they come from school on a Saturday? Saturday. they're
Saturday,
only
there is
school.
no school.
Your ladyship, if I may kindly draw this court's attention to page number 89. The written arguments filed by them, wherein they had requested only for 4 hours before the court. And now the prayer made is much more than what
Whatever
was
is the
requested
prayer, we
before
will
the
not
court.
consider all that. Whatever is the prayer, that we will not consider. let us understand what is this. The court has granted 6 PM to 8 PM. Uh. It is on
Your Lordship,
Saturday.
kind permission, may I make this submission? I'm sorry, I appear for the respondent. May I request the matter be taken up on Tuesday, my lord? I'm sorry.
So many times it has come up. earlier
First time,
also.
this is the first time it's coming up.
After my appearance.
Anyhow,
sorry,
why
but-
do you want time? We will discuss such a small issue.
I'm
When
slightly
you-
indisposed
when
today. I
the-
had some personal
No, when the
inconvenience.
other
That is why.
IAS of your client are decided in a
Yes,
hurry.
yes.
This also has to be heard and
Yeah, I'm
decided.
just on,
It is,
on,
no,
because I have,
it is, no, Mr. Arvind Govindraj, it's a very simple issue. Now the court has granted only 6 to 8 PM, only 2 hours. Let's just extend it on Saturday and Sunday also.
Lord, there are certain events that have occurred last Saturday, which I want to bring to your lordship. That is all. Lord, I have absolutely, your lordship's
And
aware.
as
I
you
have
know
no
that,
objection.
No, as you know, whatever that is, it will not make any difference. Ultimately, court will grant unnecessarily one more day, one more case has to be listed. That's
Only because certain, both are advocates. I only want to bring to your lordship's notice certain developments that have taken place last Saturday. That is all. And besides, the husband is not even complied with your lordship's order so far as
have it
maintenance is
tomorrow.
concerned. May I request Monday? Lord, I have some inconvenience today tomorrow. That is why.
Tomorrow at the top of the list. Yes,
Till number 28.
yes.
Please, my lord.
For the appellant in this matter. Yesterday, I have convinced your lordship about the payment of court fees and the valuation.
No, you have not convinced.
That's all. Then I will argue once
Argued.
again, no problem. Oh, no problem.
There is no time to convince her. It's already 4:47.
Then Monday,
Ready to
Tuesday,
the caption for dismissal. Pose this matter on 14.
and the interim order may kindly be extended.
Interim order earlier
But
granted.
in the meantime, I request your lordship, could not heard, that is a caption dismiss as.
It's already
Much.
deleted. Yes, next MFA.
29. Till number 29.
But
Tarun
I
Bhaiya.
made applications for impleadment.
Hmm.
The reason is this, the appellants who are before this court, in a petition for restoration of the suit, the person is dead. And as against the dead person, they intend to come up on record. And there are nobody to come. I have filed application that I am a purchaser of the property. By a case auction, after the suit for specific performance was disposed of, sale was conducted, and the sale deed was executed, I purchased from the person.
Where is the petitioner?
They are, yesterday, the day before yesterday, they took time for it being posted today. Today they are not there.
No representation for the petitioner. It is submitted in the appellant's last occasion also. On their request, their matter is adjourned. Post this matter on 14th, finally.
Till
Counsel with the respondent is present, yes. 30.
till number 30.
That the whole petition is against the dead
30.
person, they are taking summons.
Yes, 30.
For appellant, my lord,
Hmm.
now I have filed a objection to the commissioner report. That the pendency of the appeal, the commissioner was appointed to inspect the property. And the commissioner report was filed. And the Honorable High Court directed to file the objection to the commissioner report along with the
Copy.
photos. I served the copy.
No.
The counsel of the petitioner submits is filing the objections to the commissioner report and he served a copy of the same, the counsel for the respondent. At the request of the counsel, the respondent poses matter on 10th of September.
And 2 weeks time may be granted. My lord. Already cross-examination, my lord. My lord, yesterday cross-examination, the matter was posted for the evidence.
You have urgency.
There is no interim order in this appeal.
And
We
then-
will, on 15 days time may be granted. I will complete our cross-examination in the
Please
trial
wait.
court.
Yes,
This appeal is against a interim order which was granted in the year 2021.
correct, but no.
There is no,
There is no stay, where is urgency?
but
Yes.
it's
12th
really
of
dragged on.
September.
And 27 date is fixed, my lord, further
12th
cross-examination.
September, yes.
Please.
Till number 31. G. Balakrishna Shastri.
Appellant, my lord. The matters before your lordship for extension of the order of stay. By oversight, the matter was posted on 25th of July before the honorable court. Detailed arguments were heard and a detailed order came to be passed. By my oversight, I failed to ask for extension of order of stay and therefore.
So now the order of extension was discontinued, my lord.
When is that?
My lord,
Which month?
And on
25th of,
25th
it was not discontinued. The-
25th of July.
Yes, yes. ma'am.
The IA number 4/24 is filed seeking extension of the order of, extension of the interim order. It is stated that when the matter came up on July
25th. ma'am.
25th, by the plaintiff could not request, though the matter was heard, could not request for extension of interim orders. Accordingly, I number 4/24 is ordered, and the interim order earlier granted on so and so is extended till the next date of hearing. Post this matter.
And one submission, my lord. There is an order of matter before the judicial registrar for recording the evidence. Tomorrow, the 6 weeks will end up, Your Honor. Another 2 weeks may be time granted.
Post this matter on September 10th.
No, my lord,
Tenth.
2 weeks
And
time may
2
be
weeks
extended.
time may be granted for extension of inquiry, my lord, which expires tomorrow.
What is that inquiry?
There,
So they have filed a contempt.
disobedience, may I submit? There is a disobedience I have alleged against other side. Inquiry has been ordered. Inquiry is going on before the registrar judicial. The court had directed that the inquiry be completed in 6 weeks, which expires tomorrow. So our humble submission is that the time for inquiry be extended for a further period
Why
of
it
2
could
weeks.
not be concluded?
No, again, in the middle, the matter was, came up before.
The earlier time granted by this court is extended by 2 more weeks.
Much
for
of it.
completing the inquiry before the registrar. Post this matter on September 10th.
Much of it.
Yes,
Sale number 32.
that is also adjourned, 32.
Your Lordship, paying for stay, it's challenging the
32 is not adjourned in the morning. Is what?
32, Your Lordship, challenging order of probate, Your Lordship. The appellant is the son. The respondent is the grandson, Your Lordship. The testator had 5 children. None of the children have been made a party to this will.
Respondents are not there.
Lordship, I've been pressing for stay. They've actually filed, they're moving before the tehsil.
More.
My Lordship, one submission, that this is an ancestral property and it's been held
See,
obliged.
if you insist it for today, then you will not get an
No, no,
interim order.
Sale number 33.
Yes.
Krishnamurthy. 33 Krishnamurthy.
There's delay of 18 days in filing this appeal.
Notice.
Notice.
Sale number 34.
Only to respond 1 to 6, my lord. Other respondents are not.
Are not listed.
I'll file a memo.
Memo to that.
Please go ahead.
Sale number
If
34.
you want to file a memo, then after that we'll order notice. File a memo tomorrow.
Please, ma'am.
We'll post this matter on Monday.
Also annex D and
You-
D1.
Whatever it
I'll
is.
file translated
Tues-
copies, madam.
Tuesday. By the time you file memo, then we'll order
I'll
notice.
have the memo filed in the office.
Yes, yes, 34.
Sale number 34.
For the respondent,
Retail.
I filed application for vacating the interim order. This writ petition is in against the interim order as an interim maintenance awarded by the family court. So family court awarded interim maintenance of 20,000 rupees per month. This honorable court, while granting interim order, restricted to 10,000. As against that,
He's paying.
I filed application.
He's paying.
2 months arrears is there. On 8,
2
7,
months he
20
has to pay.
2 months, 20,000 he has to pay as directed by.
Arrears.
On 8/7,
No representation for the petitioner, counsel for the respondent is present. Post this matter on 21st of August.
Sale number 35, 36 urgent. 37. Sharvana S.
For the respond number 20, my lord.
For respond number 13, your lordships,
Memo for retirement filed by advocate for R13.
I undertake to file my wakalat today, your lordships.
You filed wakalat for 13.
13, your lordships.
You're filed or you're going to?
I will file it today, your lordships, today or
It
tomorrow.
is submitted that, what's your name?
Advocate Aparna.
Aparna is going to file,
Senior.
Senior, this one five, but.
right? Yes. So and so has instructions to file wakalat on behalf of R13. Post this matter also on 21st. Yes, 38. That we will, yes.
Sale number
A memo
38.
for retirement by advocate for R13 is accepted and permitted to retire. Yes,
Sale number 38.
Your lordship, the day,
My lord, the date.
21st. Yes, 38th.
Sale number 38. Navinandan DT.
This matter on Wednesday. This all this 2024 on Wednesday.
49.
Oh.
Serial number 41 adjourned, 42 adjourned,
39 is concerned.
41 is 1 minute,
Serial-
41 is
41
adjourned, 42,
Serial number 39, I have to make maintainability submission, my lord.
39.
39,
Ah.
that is maintainable. There is no commercial dispute between the parties.
39.
Respond number one property has been acquired for the formation of national highway.
I will hear it on Wednesday. Yes.
Serial number 43,
Appear for the
Market,
appellant in this matter.
I'm preparing for the caveat arrest.
Hmm.
Day before yesterday, my lord, the matter was called in the afternoon. Both were not presented. I request, asked the court officer, it was adjourned to 28. Thereafter, my learned friend,
Hmm.
he has appeared later and he has argued, my lord. Now it is posted for judgment today. So caption.
For
may be-
judgment is, it's only caption for you to come.
No,
Still the
no,
court
no.
will hear you.
No, 28, the
No,
date
no,
was given.
court will hear you. For hearing
is
only
why-
it is posted. Court
is
is not
why
going to pass
did-
any
I
orders.
did not know. Court
Judgment
officer-
is because I heard him, at least by looking at the caption, you will come.
Yes. No, no, no.
He has posed this matter on when?
Any day, 14th, no?
Tomorrow not much matters. But it will be tomorrow.
14th or
No, no.
20th.
Don't add other matters, sir. Whatever they're like. Let it be. We can, yes.
14th or 20th.
Tomorrow, no, tomorrow we'll complete it.
Yes.
Tomorrow less list would be there, so judgment we can complete it. Yes.
Yes.
All these final hearing matters 44, 45, 46, let it come in September 11th. Yes. What about your Passover matter?
Passover 12,
Learned Senior, I deeply apologize that Learned Senior is stuck in a different matter, so he sought for a short accommodation. my lords. Can have it
21st
on
or 22nd, my lord?
21st,
21st, yes.
grateful.
Grateful.
Any files?
at the request of both the councils and the. Level 9. Level 9.